Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500. And you're charged with theft of a firearm worth less than $2,500. And you're charged with theft of a firearm.
Have them send someone with more experience.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not true.
Dati mihi Anglican police, verbal Latino.
Is that correct?
Oh, for Trump's sake. I didn't ask you to interrupt me.
All right, I've got 3 for 3. Here we go. All right, welcome. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It must be a Friday. Everything's going to crap. Welcome. It's good to have you here. My lights are not working right. My glasses are not on. I just stabbed myself in the eye with my glasses. How does that even happen? That one's kind of smart. All right. You can hear me again. We'll turn this down a tiny bit. Happy Friday. No Pants Friday, of course. Why is that light not on? All right, there we go. Good morning. Good morning, and we made it. Happy Friday to y'all. Everything out of the way. I've been so productive. Let's see. Emily Jane, I have such amazing news. My lawsuit's settled. Awesome, Emily Jane. That is awesome. Congratulations. We have a couple things other than Emily Jane to mention. First of all, Greeners, first in chat today. Greeners, congratulations, my friend. You being first in chat shows your eagerness and willingness to do everything IP related. And so because of that, we're going to punish you. Everything IP related is your responsibility for the rest of the day, at least until we go live again. Let's see. Today is Jose Soto Escalara judge's decision. He's going to release a written decision and possibly verbal as well. I think that happens today. Lots of things today. I need more professionals around here if I'm going to run the internet. Well, okay. Shots fired. No chat on screen. I fixed it just barely. The reason why I'm a little bit flustered this morning, I've been productive like Mrs. R.A. normally is productive in the morning. I actually went out and got the groceries this morning. Like I have been to Walmart and back. It was a unique experience because there was a girl that works at Walmart that was pulling orders last time I went.
Walmart.
When I bought the chicken soup because I was not feeling well. When I bought that, I bumped into her. She was actually pulling orders, and she was like standing right in front of the chicken soup. So I'm like waiting, and she's got a big blue cart with all the baskets on it. And she's like, "Oh, do you need to get by?" I was like, "Oh, it's fine. I just need right where you are. You just need to move." And I started talking to her, had a good chat, and she's like, "I can't believe I don't know. I'm pulling 8 orders right now. These people, I don't know what they're making for dinner, but they want 9 of this and 5 of that and 3 of that." I'm like, "Wow, I just don't say anything." When I went to Walmart today to pick up my order, which they bring out to our car, curbside delivery, it was the same girl. And I happened to know that our order had exactly 100 items on it. 100 different things. 8 gallons of milk, 15 boxes of macaroni and cheese, a flat of kerneled corn, just all these things that 12 boxes of Jiffy muffin mix, 8 boxes of graham crackers. And so I got the experience that Mrs. R.A. normally gets, where they're like, "Hey, how are you doing?" And they're like wheeling this whole cart out to you. It's like 15 boxes tall. And she's like, I'm like, hey, thanks, everything, I smile. I'm like, oh, it's the girl who was making fun of the people who bought 8 of one thing, and here I have 20 of everything. And she's like, do you guys run a daycare? I'm like, well, sort of, no, it's just, no, it's just us. We've, it's a family. We've got, I say we've got 6 kids. I don't tell them that 2 of them have moved out. We've got 6 kids, and she's like, oh, I could never do all my month shopping in one day. I'm like, yeah, well, us either. This will get us through most of the week right here, and and then we'll be back for more. I'm like, oh my goodness, are you buying for a food bank? We get these questions all the time, but what's funny is Mrs. R.A. does the shopping, and she spends less per person than almost anybody we know, like budget wise. Anyway, it's sort of a daycare. Anyway, let's get started. Good morning, welcome. It's great to have everybody here. We have a few things to do before court starts this morning. One of them is to watch a little court thing that Josh found from Judge Wolf, so we'll be doing that. We've got that all queued up. And this is why I despise brick and mortar retail. I don't want you prying into my choices. Usually when I buy in person at Walmart, I like to pay cash for that reason, because I was like, otherwise they'll be able to identify you by your credit card. I know they can recognize, facial recognition and everything else, but it's just, I have the illusion of anonymity if we pay in cash. All right. Define daycare. Yes. Birthday shout out form is right there. Let's see if we have any birthdays. Usually on Friday we have a few. Usually we have a couple because we have the weekend as well. Let's see, Bree. Do you say shots fired? What happened? Oh, that's right. Yes. I also read that. Big brother won't track me down over this chicken soup. They did. She found me. But I had a good talk with her and told her, I was actually encouraging her. She says she's got a couple things. Her brother is a gamer on Twitch. He plays video games on Twitch, and he's really good at games. Not doing terribly good at the Twitch side of it. And she says, there's some things I could do on a live stream. I'm scared to start. So I gave her some advice and said, look, here's what I recommend. Obviously the first advice I tell everybody is to start before you're ready, right? Because you're never going to be ready. If you are sitting out there thinking, okay, as soon as I get this ready, or as soon as I get this equipment, or as soon as I get, as soon as I practice more or feel better about this, or as soon as I have this many subscribers, I'll start. You can't. Woody, no, not OnlyFans. This is YouTube. She has some hobbies. I said, first of all, you'll be surprised if there's a hobby out there that you're interested in, even if you're just learning it. There are people who would like to follow your journey, who either at the same point or just love the hobby or want to be where you are. You can find your people. Last call for birthdays, says Josh. Greeners. Greeners is on one today, guys. I'm being roasted from all angles. Thank you. Chris Wallace gifted a membership this morning. Thank you very much, Chris. Super generous of you. That is just awesome. We also, let's see, I think we have, no, I thought I saw a message from, thank you, Red. You're doing some great work. Let's see. It's hard work. I found YouTube, but this community has been amazing to mine. Yeah, it is fun. It takes dedication and hard work, and most people don't have the experience I did, which was just an incredible blessing. Only Greeners would get away with the roast. Yeah, no, everybody gets away with good-hearted ones. But if that's the only thing you've ever said in chat, it might disappear. I know Greeners makes himself laugh out loud. There's the birthdays. Casey, Damien, Debbie, Pantoufle, Twintail Fox, and Wayne the Fourth. There we go. All right, let's sing birthdays, and then we'll start court so we can get going today because we have a lot of things. Is it dark in here? Is my camera just a little muted? Let's do a little tweak here. What do we need? A little more light. Not too much. Don't want to wash it out. Let's try about there. Okay, that'll work, I guess.
Happy birthday. You look good.
Okay, cameras are tuned. Let's see. Oh, and Gigi Sharebear says, and my brother-in-law Scott in heaven. Heavenly birthday for Scott. Okay, we'll add him right before Twin Tail Fox. But everyone stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me, if you will. La 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 la. Happy birthday to you. Happy birthday to you. Happy birthday, dear Casey, Damien, Debbie, Pantuflay, Scott, Twin Tail Fox, and Wayne the Fourth. Happy birthday to you. I almost couldn't hit the low note today. It's like the bottom end of the range. I sang it better when I didn't have a cold. When I did have a cold. Casey, Damien, Debbie, Pantuflay, heavenly birthday to Scott, Twin Tail Fox, and Wayne the Fourth. We realize there are many wonderful days. Today is your special day. There are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully, we can return some of that joy back to you and make your day just a little more special. Or begin by helping yourself to free pancakes at... I can't do it alphabetically in my head. Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. Oh, I think I missed one. 4-year-old Damien, happy birthday. Holly Mack, happy birthday to your grandson. Damien, you've got the best grandma in the world. Except for mine. So, you got the second best grandma in the world. Holly Mack, congratulations. Damien, it's wonderful. Andy's Grill, Bob Evans, Cracker Barrel, Denny's, IHOP, McDonald's, Tammy Dunlap's house, Village Inn, and Waffle House. There we go. Alphabetical order. All right. None of those are in my country, but thank you. You can order them in the mail, but they just won't be the same when they arrive. So, Heavenly Waffle House. Right, just inside the pearly gates. Hang a right. I remember when this show was less scripted. Greeners, for that, you have to do the drum solo. You have to lead us all in the drum solo. And you have to do it. It's the law. Okay, Greeners, he's doing it. Beautiful. Smashing that drum solo. You did. Thank you, Greeners. You were easy to follow. Quite easy to follow. All right. We have a little bit of court to get to before the Damien link. Happy birthday. Sorry, not Damien. Daisy. Damien, happy birthday. Daisy link trial begins. And I guess the state's going to rest today in that trial as well. So 3, possibly 4 witnesses today for the state, and then defense takes over. It's going to be great. All right. Let's go first to Judge Wolf just for a minute, just for a quick little visit, if we can. Judge, you there? Yes? Oh, good.
All right. It's my understanding we have Mr. Vaughn here.
Mr. Vaughn! Mr. Vaughn, welcome.
Bring him out.
Bring him out.
He was elbow counsel through the trial.
Oh, yes, the pocket attorney.
I did not appoint him as elbow counsel for the 3 other charges.
Bring Mr. Vaughn. Listen for the chains. That's when we know he's approaching. He is in custody after all. Deer Park Water. The judge is a fan. Judge, that is awesome. Clearly a sponsor of the show, at least for him. I'm out of Deer Park water. I have to get more. There's Mr. Vaughn.
Mr. Vaughn have any documents or files, matters with him?
Mr. Vaughn is just waking up, taking his sweet time.
All right, Mr. Vaughn, we are here on your motions that have been filed. My understanding is that this morning prior to our breaking for lunch that you had some issue
This was yesterday.
that arose where you had some issue with me or something about the way I was conducting court. Is there anything you want to address on the record? What now?
Are you gonna send me downstairs like I'm the one making the noise or not? You don't know who's back there talking. I wasn't the only one talking.
Well, first and foremost, the bailiffs, the sheriff's deputies who are operating as bailiffs are the ones who control that pod there where the prisoners are kept. So the only thing that I know is that there was noise being committed and we were almost through with the females, so they indicated they were going to transfer you downstairs. And since we were not going to get to you before lunch, I didn't see any reason that couldn't happen. So the other issue that I would have addressed is that you are here today. One of the motions that you have is a transcription. You are asking for a transcript and all judgment papers, and that's necessary for your appeal, and we'll deal with that. But the first and foremost thing is the motion to withdraw your guilty plea. In the case that we tried last week, you had pled guilty to the driving on a revoked license. So if you want to address that issue, then I'm going to let you take up each one of your motions. I have a motion to withdraw your guilty plea, a motion to continue the sentencing, a motion for a transcript and all judgment papers, and a motion to compel evidence, including copies of YouTube videos. So we're going to take those up in that order. So if you'll come to the podium, I will hear what you have to say on each one of those motions.
I don't like podiums, Your Honor.
Well, he's wandering up to the podium. I got my, my used projector for Halloween.
First one is your motion to withdraw your guilty plea. At the trial, you were charged with driving on a revoked license, third offense, and then count 2 was dismissed and count 3 was retaliation for past action. Prior to the commencement, well, actually when the indictment was read, you entered a plea of guilty to count 1, driving on a revoked license, third offense. So that waived your right to contest the issue of whether you're guilty or not guilty of that. Obviously, there's not been a sentencing hearing on that, so you would still have the right to appeal whatever sentence I imposed in that case, but you would have waived your right to contest your guilt or innocence of driving on a revoked license.
I object. The rule states that you can place a withdrawal of guilty plea before sentencing, and we haven't even been to sentencing yet. So that I'm well in the rights to withdraw my plea to guilt. I was under the pressure of my assistant counsel, and I feel like that he gave me some bad advice, and to withdraw is well in my right to do so.
Well, it is within your rights to request to withdraw your guilty plea. It is not an absolute right. You have referred to Rule 32, and I'm going to let the state just address these motions from the chair where she is so that you don't have to keep walking back and forth. But I will let you address each one of those motions, and then I will let the state address those motions, and then I'll make my ruling. So that was your argument, is that you want to withdraw it because you think you got bad advice from Mr. Spratt?
Yeah, and it's just the pressure of my first time doing this, Your Honor. I fully didn't understand what was going on. There was a lot of other things going on at the time. I was trying to do my best to keep up, and that was like a spare moment decision. And
okay, I understand. Let's move on to the second one. You have filed a motion to continue the sentencing in your case. Let me address it as it's written.
So he pled guilty to only have one charge.
Your motion to continue sentencing
now he wants to
states that you're requesting a continuance in the sentencing, that you want time to prepare some preservable rights for appeal, and that the delay is only requested to receive the transcript from the trial. All right. I understand. Is there anything you want to add to what you've written there?
Yeah, basically, requesting for a continuance because I plan to put in a motion for a new trial, and without the facts of the dates and the circumstances, what he said and she said, I mean, I couldn't give you a good, well drawn up motion for new trial to properly preserve for appeal.
All right. Then we'll move to the third motion, which is a motion for a transcript and all of judgment papers. And if I understand correctly, you're stating that motion to request transcript and all judgments and papers filed into the case to date by compellment. I'm assuming you mean, I don't know what you mean by compellment, but you're stating that you want to request that you want to request a transcript of the trial, is that correct?
Yes, I want a transcript of the trial, and I want any and all papers filed in by myself and the public defender and my paid attorney. This is not the first time I put this into the courts. It goes along with filing for new trial. There's due process errors and other errors that the record can show, and it's in the possession of the courts.
Right. Then I will hand you a copy, Madam Clerk, if you will raise your right hand. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God. I am holding in my hand a copy of the transcript of the record in his case, and I'm asking you, is this a true and correct copy of all of the pleadings, all of the documents contained within his file? And all filed. So this would constitute a complete transcript and copies of all documents. Deputy, if you'll just put that on the table, I'm delivering those, let the record reflect that Mr. Vaughn is being given a copy of the entirety of his file.
There's everything. Next.
Right. The last motion you have is a motion to compel evidence. And that is a motion to compel evidence, and you state that you want copies of you want all YouTube videos to be made available on USB or playable DVD or CD from the date of your arraignment to date. Those videos are relevance to your appeal. All right. Anything you want to add to that?
It stands for the same reasons that for all papers, to Your Honor, the same exact reason.
Okay.
This might be denied.
If that's all you have to, if there's anything else you want to add to those motions, that's what we're hearing today.
Leonard Papa, 22 months OG on the jury. Thank you for your support.
Yeah, is that I guess as she said, that's all from arraignment date?
I'm sorry?
Is that all from arraignment date?
Everything in your file, that would start with the arraignment and come forward, yes.
Okay.
Let me, before you leave the podium, you had previously made reference to and filed a motion for a speedy trial in your cases, and I'm prepared to give you a trial tomorrow on the driving on the failure to appear case. That is one of the three remaining charges, and I'm looking at a date later in the month for the trial on one of the other remaining charges so that we may comply with your request for speedy trial.
What are the three remaining charges, Your Honor?
You have
I don't remember.
docket number 2021 CR 462, which is aggravated assault. Count 1 through 6 is aggravated assault while displaying a weapon. Count 7 is reckless endangerment using a deadly weapon. Count 8 is reckless endangerment with a deadly weapon involved. Count 9 is possession of a firearm by a convicted felon. Then the case 336 is the one we tried, and that's the one we've dealt with so far.
Mindy FS OG,
docket number 337.
One more month till pink.
Is count 1, simple assault. Count 2, false imprisonment. Count 3, disorderly conduct. Count 4, public intoxication. And count docket number 2024 CR 142 is a single count of failure to appear. So that is the case that I understand the state can be ready to proceed on tomorrow, failure to appear.
Okay.
All right?
Yeah, I'll be ready for that. I do have a request of the courts, though.
Yeah? What you got?
I still have some video evidence at the jail. And
Video evidence of what?
Of the discovery that was in my discovery packet at the jail. And they're under the impression that I don't have any more court. When I asked to view it, they're telling me no.
Well, they'll be notified that you've got trials coming up. The trial tomorrow is a failure to appear, which shouldn't have any video evidence that would.
No, that's understandable, Your Honor. I don't understand where they're getting their information that I'm through with courts, and it's hindering me to be prepared when I come to court.
But we'll make sure that the bailiffs relay to the jail and that the clerk relays to the jail. You do have other cases pending. State is trying to determine whether or not they can have a trial on the 23rd and 24th of any of the remaining charges. Let me advise you that the trial that we're going to have tomorrow on the failure to appear will be by jury, but it will be a different panel of the, they won't be the same jurors. In other words, they won't know anything about your prior case. So we have 4 panels of the jury group that was brought in. Group 1 was their first trial. Group 2 will be or panel 2, as we call it, will be the panel that will try your case tomorrow.
It would be the ones that was left over?
No, they weren't here that day at all.
Okay.
So they weren't brought in. We bring them in groups, panels. So the ones that'll try your case tomorrow will be a different group.
Okay.
All right. He needs to make sure he has his dress clothes to be able to dress in tomorrow. So.
Okay.
Martha Ivy, another OG, 22 months.
Are we going to make a ruling on the rest of the motions today, Your Honor?
I'm going to make a ruling on your motions today after we hear from the state.
Okay.
Hint, hint, some will be denied, some will
Thank
be
you. Have a
granted.
seat.
Okay.
He doesn't get the YouTube videos. Best copy is the transcript. That's the official record. You can't get the video also, I don't think.
All right. General Bryson, perhaps you should come to the podium just to make things easier.
Judge, on the motion to withdraw guilty plea, I searched for case law that was on point where a plea was entered in front of the jury, and there's not a lot out there. I did not find a single case with those specific facts. I did find, and of course it is my duty to tell the court any case law that I find that is against my interest. There is substantial case law that talks about how the defendant must be notified of all his rights in a waiver and waive them knowingly and voluntarily and say that on the record. I don't think we did a rights waiver in this case, and so I leave it to the court's discretion if that would be reason for the withdrawal of the guilty plea. Based on how you rule on that, with the sentencing, normally the defendant would not need to file a motion for new trial until after the sentencing. So I don't know that he needs transcripts before we do the sentencing, only before he would file a motion for new trial. So the state would be ready for that when the court chooses. And then you have handled the other 2 motions on your own, unless you want me to address either of those other 2.
That's all right. Just wanted to give you an opportunity if you want to be heard.
Jamie, 25 months, another OG.
All right, on the motion to withdraw the guilty plea.
Welcome.
There isn't, as General Bryson points out, any clear direct evidence or case law on the point. The defendant was representing himself with elbow counsel, and for that reason, he was given some specific advice. Now, he argues that the advice given to him by his elbow counsel was, in fact, not the appropriate advice, or it was not sufficient because he did not realize that he could not appeal the, according to his motion, he said he did not realize he could not appeal from that guilty plea. Well, he can appeal the sentence imposed, but he cannot appeal the finding that he's guilty of driving a revoked license. But because of the fact that essentially Mr. Vaughn is arguing that he was not fully aware of his rights, and because this is the state pointed out, normally this is done prior to trial with a what we call the Mackey rights, where I explain all of the rights and go through that litany of rights that they have prior to accepting the plea. The only other option would have been to have suspended the reading of that indictment to the jury and his response, send the jury out of the room, and then conduct that. And probably that would have been the better practice. So I'm going to grant his motion to withdraw his guilty plea as to that driving on revoke charge.
Wow.
And we'll place that back on the docket.
He's winning.
It'll be tried separately than anything else. So essentially, you're going to have a separate trial on that charge. The motion to continue your sentencing, I'll grant that as well, so that you have time to be able to do whatever. When did we set the sentencing hearing, Madam Clerk? Do you remember?
He's costing the state of Tennessee a bundle of money.
We'll set it in January then to give him sufficient time. That ought to be more than enough time. Sentencing hearing will be on January the 28th at 1 o'clock.
He's going to ask for elbow counsel on that case.
You write this down for me. You flip that paper over right there.
Then the next motion is for a motion for a transcript and all judgment papers, which I have supplied to you. And then the last motion is a motion to compel evidence, which is arguing that you should be entitled to a download of all YouTube videos. This court finds that those YouTube videos are in the public domain. They are not evidence that was utilized in the trial of your case. And for that reason, this court does not find that there is any obligation on the court or the state to download and go back through and every hearing that you've had. You have a right to transcripts of hearings if it gets to the point where you are going to ask for a transcript of the proceedings, but you do not have a right to a broadcast of the proceedings on YouTube. The transcript of the evidence would be sufficient to show what happened in court. The Court of Appeals does not consider a YouTube video. They don't watch videos when they consider an appeal. They refer to the written transcript and the exhibits. So your motion as to the YouTube videos being compelled to be brought before you, I am denying that motion. That concludes all of the motions that were set before the court. We have determined that we're going to try the case of failure to appear tomorrow.
So he won the first motion.
So we will allow you to resume. You still want to represent yourself?
Of course.
Of course.
I do have a question for you.
What is that?
Mr. Lee Spratt continued to stand up on my trial day, and he made a statement about not being paid to do so. Well,
Correct.
From my studies and what I was looking up, it stated that over in the I can't remember the rule exactly, but it stated that all appointed attorneys were paid. Is there any knowledge of yours?
Yeah, I can tell you that he was not appointed as the attorney of record for your case. He was designated as advisory or elbow counsel. There's a difference. His obligation is not to represent you in the case and to, handle the trial. He is there only to answer questions or to give you suggestions. So as a result, it is my understanding and my belief that that he does not get paid for that. And so for that reason, as I pointed out earlier, advisor, you've elected to waive your right to have counsel represent you. And I've reiterated that question to you on more than one occasion. And again today, if you want to represent yourself, you have indicated, of course, so you plan to represent yourself. By saying that, you are waiving your right to have an attorney represent you. You do not have an absolute right to advisory counsel. It lies within the discretion of the court. I allowed Mr. Spratt to continue in your case as advisory counsel to help you through the process of jury selection, the trial itself. And after that, Mr. Spratt is relieved and has no further obligation. even as advisory counsel. So you are on your own, and you will be representing yourself until such time as you make the decision that you want to have an attorney. And when you do that, I will appoint an attorney who will take over and will handle the case, and you will simply be, listening to that lawyer, and that lawyer will be able to tell you what is going on and give you advice about that, but he or she will be handling the case.
That will not happen.
Pardon?
That will not happen.
Okay. Well,
ever.
I understand you have every right to represent yourself under the Constitution of this nation, and I'm going to give you that opportunity. But you understand what you've been through, that there are complexities about jury trials that sometimes can be very difficult to understand.
There's nothing to understand. What I understand is that the poor representation this court keeps providing. That's why I'm asking you about the elbow counsel saying that he wasn't getting paid. He should have been getting paid. He was appointed, you saying appointed as appointed, whether first seat or second seat. And he could have done more than just show up. That's all they did.
Well, you can take all of that issue about whether or not he gets paid up with the administrative office of the courts. I'm not the one who pays him or doesn't pay him.
Okay.
All right.
So
he
complains about the counsel he got, and now he's also saying you should have paid him.
I will resume the court tomorrow at 9 o'clock when we have a jury coming in to trial this failure to appear case. We stand in recess, or adjourn, rather.
All rise. Now adjourned.
He does not rise. He's getting a little grumpy. He's getting grumpy. He's like, don't touch me. Don't touch me. I'm going to walk this way. Nice and slow. Nice and slow. Wander, make a big, slow arc. Taking my time, taking my time. Going to be doing time. Yeah, that's the way it goes. Let's see. Shore Life Creations, welcome. Great to have you here. We are excited to be jumping back to our trial here in just a bit. Here with the Daisy Link trial, which is part 3, day 3. This will be the day the state rests, according to what we've been told. So we'll be listening for that. Shore Life Creations, thank you very much. Welcome, welcome. Love that orange courthouse. Why should he care if he gets paid or not? Well, why would he care if he gets paid or not if he says he just showed up and didn't do anything, and the advice he gave me was bad and I'd like to withdraw my plea because he gave me bad advice? At the same time, you should have paid him. So it's an interesting. The attorney basically, he brought to the judge's attention and said, "Hey, I'm not being paid, so you can't make me do this." Basically, you can't. And he's like, "But I want to keep doing it. I'll stay on. That's not a problem." I sort of like the guy. He's sort of grown on me and did it voluntarily. He has a nice voice. He has a fairly decent grasp of the legal system. Not expert, but decent. And he's doing okay. I mean, everything he argued today was without papers, just from the top of his head, straight from being woken up and pulled out of the jail cell. Let's see. I think if he got paid, he would have done more. The attorney already argued things, questioned people. There were 2 riders on one horse for a while. Argued things to the judge directly. Consulted with him on almost everything that happened. He did more than elbow counsel I've ever seen. The lawyer counted it towards his pro bono hours requirement. Anyhow, right. Elbow counsel did good. I think he was fantastic. Apple Treasure member for 21 months. OG. Nowhere else I'd rather be. Thank you very much, Apple Treasure. Glad you're here with us. I'm going to be going to court in just a minute. Can I get a rundown of your history, RA, how the page got named, etc.? Ozzy, sure. That's a great question. Well, the page got named initially back in 2016, I think it was, when I thought, I really like metal detecting, and I think people on YouTube would like to watch me metal detect, and I'm addicted to recovering artifacts from the ground, so let's call the page Recovery Addict. That was part of the reason. And I did that. I started, if you go back to the early days of this channel, you'll find metal detecting videos. I greatly misjudged the number of people who would be interested in metal detecting videos. It was not a thing. At least my videos were not a thing. Even though I found like some cool stuff, found the gold rings on camera and things like that. That was awesome. That was cool. But I stopped doing YouTube for a while. I do have an addiction recovery story of my own involving computer gaming, and I was about as addicted to computer gaming as you can possibly get. I nearly lost my job. I was doing things that were incredibly unsafe. I was literally computer gaming while driving 75 miles an hour on the interstate. That's how much I could not separate myself from that. Luckily, with some great support, including an amazing wife, able to be in the recovery phase of that. And so we do celebrate everyone that is seeking sobriety from whatever their addiction is here on the channel. And so the Recovery Addict channel, you'll commonly see people who will share their sobriety milestones here on the channel, and we love it and celebrate it, whether it's 1 day or 1 year or 10 years or 1,000 days, or it's wonderful. It's great to see people seeking to better themselves and free themselves from an addiction that's really been tearing them down. So that's where we're at. Occasionally we get some people come in who were seeking just addiction recovery material. We don't provide a lot of that, although when we watch court, we do sort of have an eye leaning towards concern for people in addiction. As we're watching court, a lot of times addiction will take people into the court system, and so that's there. But what if we're addicted to the channel? I think there are good addictions and bad addictions. It's just finding that balance in life. There can be too much of a good thing, right? Just the balance is what's important. Mimi D, member for 29 months. Woohoo, love it here. Thank you, RA. OG. I love that. 29 months. I have an amazing wife. I miss her on channel. We'll get her on here sooner or later. Gossip, rumor, and innuendo. Woohoo, 29 years sober. That deserves a party sound. Thank you. Thank you for sharing that. That is awesome. Kathy, thank you. Kathy, Gossip, rumor, innuendo, another fellow creator here on the YouTubes. She does some early morning breakdowns of things that happen in court, and they are hilarious. If you want to start your day with an ache in the side from laughing too hard, you've got to check out her channel. Kathy, great to have you here. Quit drinking 2 years ago, Winter Sky. Congratulations. This channel replaced my bad addiction with the good addiction. Selena, wonderful. I love that you're up walking. When are we going to run that marathon? I can't let you practice too much or else you're going to beat me. Well, I might be addicted to other people's business and gossip. we all have our favorites that we never let go of. Irvin Beasy, thanks for making it simple and concise. Recovery Addict is a former video game addict who also loves doing metal detector recovery of lost items, who just happened to become a shepherd of former addicts and court aficionados. It's funny how it happened. I guess there's part of the channel I didn't really address for you. It sort of was included in your question. While we're waiting for court to start, I'll see if I can address that. I worked for the federal government, Ozzy, back in, it was years ago, 4 years ago. It was the last time I worked for them. And it was an awesome job. I loved it. I was doing IT. Pay was great. Loved the people I worked with. It was a fun job. It was exciting. I got to sort of see behind the curtain of the security for the Department of Defense, and it was really neat. It was a top secret SCI position. Checked all the cool boxes, right? Worked my way out of a job. We transitioned all of our workload into a different data center, which I was not over, and so my contract basically ran out of work to do. And spent 7 months looking for a job. Incredibly depressing being on the job hunt, especially because I was being very picky. There were lots of jobs that weren't exciting for me, that were available, that I didn't want to take. There were a few jobs doing exactly what I was doing that would require me to live in great places that I just didn't want to go to, either Florida, Washington, D.C., Denver, Colorado, things like that, Mechanicsburg. I wanted to stay in North Carolina, and so nothing was lining up. And eventually, just tired of doing a job search, I put together some of the equipment that I have from my schooling, my education is in electronic media, live event production, that sort of stuff. journalism, and put that together and live streamed something that I was interested in, which was court. It was the Darrell Brooks trial. And the first day we had 13 people here. Then we had like 45 the second, and 450 the third. And the fourth day we had 13,000 people. And it just exploded. And we've been doing it full time ever since. Selena K, next summer, so you better be ready. All right. I've got to get in shape. All right. Anyway, that's sort of in a nutshell what happened. And honestly, the most amazing part of it was not how quick it happened. The most amazing part was how incredible this community is that is right here. I mean, it's different than anywhere else on the internet. You can't find another group of people that is just so kind, caring, nice, everything. It's wonderful. Looks like... Why is that not working? Is that our defendant just chilling? It is. She's just chilling there. Okay, menu. Where's storage? Right there, storage. Set network location. Just going to go to Black Magic. Well, we'll just leave it as is. No audio yet from court. I believe that's our defendant. Recognize her from the tattoos. Not sure why she's sitting in the jury seats right now. On the opposite side of the courtroom from where... Oh, I do know why. It's because the judge has a docket this morning. The judge has a docket of things that she's trying to get resolved. So with the camera audio off, we're waiting for court to begin. That's why we're here. Okay, Kelly H., thank you for the super sticker. Cool. It's cool. Ozzy, hopefully that answered your question. I didn't see a response from you, but I wasn't particularly looking, so... I like buying your house story too. That's a crazy story, Laurie. There's the answer. You're welcome. Any other questions? Always welcome. An honest and sincere question, even the personal ones. Some of them I don't share online, but generally I'm a fairly open person that way. Let's see, Samantha. First 1K sub right here. It's been a trip. It's been incredible, Samantha. And thank you so much to our amazing moderator, the entire team who put in so much work. And honestly, they know this community so well, like the mods do. They hopefully this isn't giving too much away. They know when somebody's having a bad day, and just they know when somebody needs just a little personal contact with the moderator, thanking them for being there or something like that. They're incredible, absolutely incredible moderators. Could not do this without them. Crunchy Frog member for 16 months. Whose bowling bag is that? I guess that's her attorney's. This is a crazy case. First of all, the audio is really bad most of the time because the judge doesn't use her microphone. The judge has ordered the prosecution and the defense to stop looking at each other, because when they look at each other and they're like, American Disability Act is not in compliance here. Their tables are 4 inches apart, and that's where they walk through. They mouth words at each other, apparently. Somebody called somebody a B, and now the judge is like, don't make me kick you out of the courtroom. So that's happening. Again, not a terrible shirt. She's got style. She is in custody. Let's see. Appropriately dressed. I think that helps a lot for court. You're not getting judged by your clothing, right? It's not like the fashion police are coming in to say, are you guilty or not based on what you're wearing? I mean, if that were the case, I would lose every time. I mean, the number of times I wear gray with gray is just... Mr. Ray could tell you, I have trouble dressing myself. But your appearance to the jury is important, and a lot of that is demeanor. So I think she's done a fairly reasonable job today, or in this trial. It's way too cold in PA today. It's a little chilly all around. I think there's a nor'easter coming. Here since Brooks, but not a member till later. Makes you an OG. Let's see. She is in jail. Even though she's in jail, when there's a jury trial specifically, if this were a bench trial, it would be different. But when there's a jury trial, we talked about those appearances to the jury. It would be prejudicial to have the defendant, who has not yet been convicted on the charges, appear in basically a jail outfit in front of the jury. So pretty much across the U.S., defendants are allowed to appear in street clothes, just regular clothing, so they don't. I mean, if every time you saw somebody, you saw them in like an orange jumpsuit or the black and white stripes or something, you would be associating with them with, yep, they belong in jail. That's where they are, and that could prejudice you to make it more easy to say, yeah, she's guilty. You know, she's a jailbird. You know, that's it. That's the wrong term, but. This particular defendant is made the news before this trial even blew up on the radar. It just being what is sadly just a simple murder, because she got pregnant while she was in jail, and she got pregnant while she was basically isolated in jail. And people say, "Wait, we know, you know, we followed along in health science class. We know that's not how it works." Well, they found a way. And it involved an air vent and communication from a neighboring cell, which housed a male inmate, and the air vent that went through between the two of them, where they could pass notes and tiny packages of DNA back and forth. And she was able to get pregnant and gave birth to a child in custody. So she has expressed that she should be thanked by the jail for pointing out their security flaws, and yet they have not done that yet. I don't think they're going to. Request to submit Pickles into evidence, Your Honor. P.S. This is the Brit Bottoms on my other account. Brit Bottoms, Lavender Lux, welcome. As far as pickles, I got 2 jars of pickles today, but they were just dill. I did not get the good ones, which are spicy maple bourbon pickles. But we do have 2 jars of pickles on the grocery list today. So apparently you can get pregnant from a toilet seat. Oh, my goodness. Oh, my mother was right. Whoops, sorry. I just broke everything. I'll fix it. I clicked on the link that I should not have clicked on. Okay. Go back here. They're moving the TV, so we might be able to see at least part of it today. That would be nice. I don't want to get into the details. No, we're not going to. Gossip rumor innuendo. Kathy said he submitted product 5 times per day. It did take multiple attempts. I'll say that. Lavender, the package I sent you was delivered. I have to send the kids to the post office box. Is it something they can ride their bike, my e-bike, and pick up, or is it too big? It's got a little pouch on the back where it can hold packages. Our Walmart wants $8.50 for spicy maple bourbon pickles. They're good, but they're not that good. They should be $3.49 range, $3.89. I would not pay over $4 for them unless I was very, very hungry. Chat not on screen. I'll fix that. And 9 months later, little Aaron Venti was born. Yes, Zach. That's how it happened. I like to imagine this is a court simulator, not a real court. Cass, 24 months. You hit the 2-year mark. Turned pink on the podcast last night. It was a fun night. Thank you, Cass. That just makes you an OG. Thanks for joining us on the podcast. That was a lot of fun. thinking of Thomas today. He's got a 10-hour drive. 10 hours of driving he's doing with a buddy who needs some help going to go check out a motorcycle he might be buying. But 5 hours one way and 5 hours back. Maybe he's listening to us in the car. That's a long drive. It's a long time to be in the car. But Watch is a great friend, and it's awesome he's doing that for his friend. I feel like starting to fire my fireplace, but it also feels like a lot of work.
Sorry, Detective Janoris, this morning and start her testimony, that would be ideal. If not, she can testify in the afternoon. And
she's the state, right?
Correct. She's also I'm also going to be introducing a jail call through her as well, and publishing a jail call.
Is there an agreement from the parties on the contents of the statement?
So,
that need to be skipped over and redacted?
So late last night, I finished going through the entire 11-hour statement. I finished around 2 o'clock in the morning. So I didn't want to call Mr. Tomas at 2 o'clock and wake him up. I have timestamps of what I believe are either irrelevant or inadmissible. Mr. Tomas and I spoke briefly this morning. The only actual issue I believe that exists, there is a point in time in which when Detective Janoris walks in at some point, she goes to Ms. Lang, I have a question for you. What happened on Monday? And I can't remember the exact words that are used, but Ms. Lang volunteers that she smashed the window of the truck that we discussed during the Williams rule. Ms. Link's response to all of that in context is that was immediately after the victim had pistol whipped her. I can mute that portion in time because obviously the court says that could not be used as a Williams rule. I do think it's relevant in this case, in that context, but if the court's order is that cannot come in, I'll mute that entire portion.
So Janoris comes back in, and that's an isolated mini conversation.
Yeah, it's I have my timestamp here. It is during the full 11-hour statement. It is at 8:29. 8 hours and 29 minutes, and it goes 8 hours, 29 minutes, and 17 seconds.
But it is isolated.
Correct, yes. That's the only actual portion about the truck that's ever involved, but I do think it goes directly to the state of mind of the defendant. It goes directly to the defense's argument that had been brought out multiple times now that the victim had pistol whipped her prior to, that she was in fear, et cetera, et cetera. I think it goes directly to her state of mind. If the court's ruling still is that I cannot bring that up, I would just ask to revisit it on rebuttal at that point in time, but I understand whatever the court's ruling is.
Let's just work backwards. Do you want that in or out, Mr. Tomas? Okay, so it'll be redacted.
Sure.
Muted, however way. The other parts regarding this person getting arrested, that person getting arrested, are both sides in agreement for those?
So I've muted, let me phrase it this way. I have my lit support currently working on muting all specific mentions of any actual acts of domestic violence or arrests that are brought up. I intend to elicit testimony from Detective Janoris that this was a volatile relationship, that there were acts of domestic violence that were occurred, but I don't want to get into the specifics because as Ms. Link mentions.
Let me ask you this, how are you going to ask Janoris about their relationship?
Did the defendant tell you that this was a volatile relationship? She actually, the exact words that Ms. Link uses in her statement was this was toxic as hell.
Okay.
Did she tell you that this was a toxic relationship? Did she tell you that it was volatile? Did she tell you that there were acts of domestic violence that were committed by Pedro Jimenez against Ms. Link? She will answer yes.
But all of those words that came out of Ms. Link's mouth are in the recording, right?
To a certain extent, yes. Ms. Link gives specific examples. She says she woke up in a bathtub. She doesn't give a time, a date, anything like that, but she says it happened a while ago, which is also corroborated by Ms. Link's statement to other officers that, yeah, Pedro had a past, but that was very long ago. Ms. Link also talks about how, with the bathtub incident, she says, well, that was the last time I got arrested.
But why revisit it again with Janoris? What's the purpose?
Because as of right now, those things really haven't come into evidence, right? The actual acts of domestic violence that are spoken about are not really.
What's the purpose of having Janoris highlight?
I'm not highlighting.
Half a dozen so.
No, I'm not going to have her speak about any of them. And as we talked about yesterday, the only thing that I'm going to have her talk about is, did Ms. Link tell you it's a toxic relationship, etc. Did she tell you there were acts of domestic violence? I don't intend to have her say, yeah, she told me about the bathtub incident. She told me about this. She told me about that.
I'm not answering my question. What's the point of having Daenerys repeat these? The jury's already going to hear it from the video. Why?
No, they're going to be muted because, again, the court's rulings during the motion in limine that those specific acts were not coming into evidence. The only actual act that was going to be discussed was the pistol whipping incident from 5 days ago. So what I'm asking Detective Janoris to testify to is, did Ms. Link tell you that there were acts of domestic violence? She will say yes, and then I will stop. Did she say that there were acts of domestic violence that Ms. Link also committed against Pedro Jimenez? She will say yes, and then I will move on. And the reason why is because it shows the totality of that actual relationship, and it's inextricably intertwined with my theory of the case that this was a toxic, volatile relationship with domestic violence going both ways.
So, Judge, what I would say to that is nobody's disputing that this was a toxic relationship. My concern is we have a statement where Ms. Link talks about why it's a toxic relationship, but we're going to mute that, but then we're going to let this person give a secondhand account of a statement that's going to be in, but it's going to be redacted. I don't see why those two scenarios should coexist.
Well, so I don't have to play the statement at all. I don't have. I can publish only even portions of it. The law is incredibly clear that I'm allowed to present evidence as I want to. That this is not applicable to the best evidence rule either. And again, the court has already ruled that those specific acts of violence, either way, are not coming into evidence.
So then why would I allow Janoris to say in court? They can't come in.
I'm not going to ask her about specific acts. I'm going to ask her, did Ms. Link tell you about Mr. Jimenez committing domestic violence? Did Ms. Link say she committed domestic violence? I'm leaving it in a very broad sense because Ms. Link talks about her actual arrest, which I don't think, based off the defense's arguments last week, and the court's inclination prior to, that can come in, right? We're talking about the second phase of the case at that point in time. Same thing with the victim's arrest. She says he was arrested for this, the bathtub. He wrote a letter to his mom. None of that is relevant to this case.
So you want to be able to corroborate that there was domestic violence on both sides.
Correct, which is my theory of the case.
So what you want to do is the half dozen or so specific incidents from the actual video, based on my ruling, shouldn't come in. But the state still wants to paint a picture that there were acts, not necessarily criminal acts on both sides, and it sounds like a pretty general, they want to elicit pretty general evidence from the detective regarding that. I think based on the way that they want to elicit it, it won't be a feature of this detective's testimony.
No, it'll be seconds.
So what's...
Well, if it's limited to the very general questions that he just...
Yeah, I misunderstood. I thought you wanted Janoris to say, wasn't there rats in the incident?
Absolutely not, no.
Okay, that was my bad.
Okay, so if it's limited to those very general questions, then
Right, and so it goes into the theory of there were ups and downs,
That's
you
fine.
used the word volatile, so I'll allow that.
Judge, I want to give you a heads up. I just sent you an email. I copied the state. So there is an order dealing with the custody of the kids. I did locate it. It's part of the dependency case. The clerk will not give me a copy unless you sign an order. So I'm asking, I sent you a proposed order. I don't know if you want to tweak it a little bit, but I tried to cover all the bases there. They don't have the file right now because it just so happens that just yesterday they finally quashed that pickup order, which had been outstanding for a long time. So just so the court knows, now that pickup order is quashed, maybe Ms. Link's mother will change her mind and provide Pedro Jr. I'm going to be at the state attorney's office on Monday morning to conduct depositions anyways. So if she brings Pedro Jr., then we can resolve that on Monday morning. If she doesn't, I have no control over what she decides to do, but Just wanted to make the court aware of it.
We'll still need to litigate a few things regarding that child, and then I would also, so I don't know the statute off the top of my head, but there is a statute that says any party, including the court, can move for a hearing on whether or not it'll be traumatic to a child witness to testify in front of the defendant. If we get to that point, I'm going to be moving for that child to be given his testimony, not in the courtroom as well, but we can cross that bridge when we get there.
So I'll go ahead and have the set threaten me a copy of this.
Wow.
It's like it's fine based on our review, I'll sign off on it. But this is for your case to change, right?
Having her son testify.
Your case, so you may not, hopefully they get it to you today.
They're not going to get it to me today, Judge. They said that if I show up, they're closed on Monday. I show up Tuesday morning at 9 with a certified copy, then they'll give it to me. I'd ask, because they don't have the file because it was in court yesterday, because they just signed that order.
Do you know which judge it's with?
Probably not the same judge anymore, but.
How do I say this now?
I'm sorry, I just emailed this one. Oh, sure, thanks.
I'm not sure which judge it is, Your Honor.
We made some phone calls. But you want to present this when you start your case on Tuesday?
Yeah, it's a self-authenticated certified document. Looks like Michelle Alvarez Barracat signed the order, the old order. I don't know if there's a new judge assigned to it now. It just says cancellation.
Still over there, so it's probably.
Okay.
We'll make some phone calls.
And Judge, I'll send you, if you don't mind, once there's a certified order, if there's a way that you can email it to this supervisor clerk, and I'll send you the email. Just, I don't know, so.
Once my JA gets it, I'll have her send it over to the clerk. She can copy both sides, and I think I can ask for a certified copy, which probably I'll probably get it before you get it on Tuesday.
I would think you would.
Let's hope they do that. I'm sure they will. I'm sure they're probably giving that professional first.
Thank you, John.
There's one other issue that I spoke to Mr. Tomas about that I think is actually very.
Going back to the statement.
Sure.
We'll just talk about it over lunch.
Yeah, absolutely. I have, like I said, I have my own timestamps. I'm asking Mr. Artal, the reason why I'm doing this is we don't have the actual statement yet. Like I said, I finished it late last night. I have timestamps, but when I went to my litigation support team this morning, their timestamps are used on a different program that is significantly more accurate than the program that I am given. They're off by about a minute or so. So while we're in the trial, Mr. Artal is confirming the actual timestamps, but I have what I have, which I think.
What is he literally recording?
Basically. Basically.
Your Honor, so there's essentially internal timestamps that are already embedded into the actual interview, so I'm just cross-referencing those.
And then I'll be able to provide a copy of that to everybody, but I can speak to Mr. Tomas about what I'm actually planning on redacting and removing from that video itself.
I wanted to, I'm just going to tell them what to take the jury on that side. Can I revisit a little bit what we discussed yesterday regarding the
First Miranda?
Yes, but also the I'd like to file my email with the court as according to the one. My concerns regarding the spontaneous statement. Okay. Nothing in this email is anything different than what we generally discussed before, but it narrows down my concern about the way that the spontaneous statement came out, and my belief that the instruction I gave to the jury about how the jury should view the spontaneous statement, I think I'm correct. So I just wanted the appellate court to see what I was thinking and the case law that I provided to you all yesterday, so that would be Court Exhibit 1. Well, in the context that it was said, it was pretty jarring. I understand it may have fallen into the spontaneous statement category. We haven't heard all the evidence yet, and the jury is supposed to keep an open mind. If Ms. Borrello testifies and more evidence comes out about Ms. Link and her self-defense claims, I think that statement is less impactful. Does that make sense, Mr. Thomas?
Yes, right.
We still have to look at we're only halfway through the trial, we
Yeah.
still half more evidence, half as much more evidence that needs to be admitted, and there's nothing stopping me from saying something along the lines of the family knew it was quote-unquote a bad relationship, and it's not unreasonable to believe that something bad was going to happen to either side, something along those lines, right? Okay. Not yet.
Yes.
All right, did you and Ms. Link talk about the Miranda waiver?
What is it on?
Yeah, what is it on?
Yes, she wants the whole thing in, including.
I went back and I looked over the Miranda waiver in the second one. While the police say something along the lines of, so you want to talk to us, we have to go over your rights again. They use the word again a couple times.
Which, sorry not to cut the cord off, that's muted.
Well, I was going to say, that doesn't indicate that she has invoked her right to remain silent. Just because they're going over the Miranda rights a second time or again, it's not a comment on the silence. So yes, the state is going to mute that. I don't think they need to mute that because this doesn't indicate that. My concern is a comment on the silence. So.
Yeah, I would just ask they play it, but no commentary, no unsolicited comments from the witness like we had yesterday with that detective.
My point is, it's not necessary for us to talk about the first Miranda.
Yes.
Because the second Miranda doesn't indicate a comment on her silence or the invocation of any rights, number one. And number two, since it's in the benefit of Ms. Link to have this statement come in, I would think that we would want to streamline it.
Yes.
Do you understand what I'm saying? Yes. So if you, as you and the lawyer, believe strategy-wise, it's better for you to have the statement come in, it looks like it's coming in with certain protections. For example, the jury's not going to know that you were arrested. Does that make sense? Okay. So what would be the logic in bringing in the first statement where you invoked it?
Because they spoke to me outside of the door either way. They were speaking to me the entire time, even though they weren't supposed to. They basically coerced me into signing that second sheet when they took me to the bathroom with an entirely different investigator from the DV department.
But at this stage, you're agreeing that what's in the full interview is better for you
Correct, yes.
for this trial. So why can't we just move on and not from your point of view, understand that you're getting an overall benefit, even though there's parts of it that you don't agree with, the way that they got you to speak, for example.
I can understand that.
You also understand that there wasn't a motion to suppress filing. So the court didn't have the cops come in and prove to me that your Miranda statement was a knowing voluntary waiver. We didn't have that argument. That's a constitutional motion that could have been filed, just like the standard ground, but that wasn't in front of the court either, right? Right. So that, to me, that's also like a strategic point of view, strategic move by the defense, right? Yes. Okay, so do you want to so it sounds like you don't want to talk about the first Miranda waiver. Yes. Because if you do, you and I have to have an in-depth conversation about what it means for this jury to understand that you invoked your rights, and essentially it's a comment on your silence, which has all sorts of huge constitutional ramifications that need to be weighed in this courtroom for appellate purposes. Does that make sense? Yeah. So why don't you just talk to her real quick about us not going into the first Miranda?
I'm just going to step outside.
Yeah, we'll step outside too. You all the record, Jason?
Her waiving this right. Her waiving this right, and then it's not going to be as big a deal once she takes the stand, because I think it's not a big. I think it's not a big deal. But she has issue. She says she was coerced into signing the second Miranda right, but she wants to have everything brought in. it sounds like she doesn't like the process, but she thinks something that was said during that interview after the first, or maybe after the second Miranda warning signature, that she said something, or something was said that benefits her case. So she wants to bring it all in. So she has to waive the right to. This is going to be a little weird, but it might make more sense once it actually unfolds, because we don't know the content of what was said here. We're sort of just basing it off the sort of vague legal ideas that the judge is making a pathetic attempt to express. And I apologize if I'm insulting this judge. I'm sure she has a more broad legal understanding than I do, hands down. Articulating it is not her strong point. She misuses words. She uses the wrong opposite word to say things, and I just don't get what she's trying to get to in this one. She's not a great judge in my book. Just like on a foundational level. Obviously, I have strong disagreement with her as where she stands on public access to her courtroom. Maybe that's influencing everything, but I'm struggling to like her, or even respect the effort that she's putting in. Especially we who labor here seek only the truth. Let's see. Have I not gotten into the Facebook page? I need to join Discord. If you haven't got into Facebook, just make sure you answer the questions. We get a lot of people who join the Facebook group and then refer it to their friends. And their friends just say, oh, so-and-so referred this one, I'll join. And they just click join. And we don't let the friend in because the friend does not answer the questions. The friend has to answer the questions too. So even if it's referred by a member, make sure if you're referring somebody, they know that they have to answer the questions. Otherwise, they will not show up. We'll check. Samantha, thank you very much for doing that. She's not allowing the process to roll out effectively as it's supposed to. She does seem to be more involved in some of the strategic decisions of the trial than we've seen in other cases. But I will say that possibly a mitigating factor on that is that this court is allowing the camera to roll more than we've seen in other trials. So we're sort of seeing more behind the curtain stuff that that might be done in other trials in judges' chambers or something like that. So this could be fairly normal, but we're just seeing more of it. She treats the courtroom like her house. It's not her house. Let's see. The questions are so hard. I can give you the answers if you want. Let's see. There are a couple questions. Are you a camel? Basically, that's a freebie. I'm not a camel. Is the answer. That's the. Let's see if I can find it. Yeah, this is the answer.
I'm not a camel.
That's the answer. There's one question about when did you. This is the Facebook questions. When did you first start watching the channel? And you could basically, as long as you can name a trial, including the one today, you're good. You're good. And there's one about, will you follow the rules and be respectful? And the answer there has to be yes. It's the most important question. Wait, there's a Facebook group? How do I find it? Says Laura. There is, and Red Pen just posted the code, which we'll put the link. There it is right there. You can join us there. Facebook is a place where we try to stay on topic. It's not a place to really post a lot of advertising and things like that. We try to stay on topic, but we allow things over there that we don't cover directly on this channel a little bit, within reason. It's not hugely different. We still ask that the same rules apply, that we're respectful to each other. And, what if I am a camel? You probably could get through saying you're a camel as well. That's all right. We do have some dad jokes, some true crime jokes. A lot of pickle posts are show up there. Just fun things we've seen, or little. We see some, some life moments, some inspirational moments of achievement from different members and things like that. But it's a fun group over there. All right. Yes, Cass, you need to answer the silly questions. Try one more time. You can do it. You can do it. I know it. You just make sure you scroll down before you click the join button. Let's see. Uh-oh. The Discord link might be having issues. I'm not sure if Amber is with us yet this morning. She's actually hard at work, probably. We'll see if we can get that fixed. We do have a few pet pics that show up in there as well, for sure. Josh, we do have Judge Brantley Clark on record right now. I'm showing about 54 minutes into that recording this morning.
Yes, sir.
How are we proceeding on the first Miranda?
So,
No.
So we'll leave the first one out, and like you said, they're going to say you're going to read your rights again. That's fine.
I'm muting the part where they say we're going to read your rights again. It's just going to go into Detective Jim Norris. I can show everybody later when I have the actual redaction because I don't remember it.
Do you think it's?
I just don't want any mention of again or anything like that.
I would ask that again, State. That's the one thing.
Again, it's fine because it's not a comment on her silence.
Right, but it implies that she was already read her rights, and that's my fear. If Ms. Link is willing to waive that appellate right to at least that portion of it, I'm okay with leaving it in. I'm just very concerned about even going near the idea that Ms. Link had invoked at any point in time. That's my fear, and as we have said a number of different times, I don't want this case coming back, which there is just case law after case law after case law that says any mention about any kind of first indication of Miranda rights is reversible error, and I don't want to even come close to it.
I know it's nuanced, but the second reading doesn't, it indicates a second reading. It doesn't indicate an indication.
But Your Honor, they wouldn't even see a second or a first reading.
Right.
It will essentially be cut off.
And
Hold on, I understand where you're going regarding the influence, but if nobody makes that argument, it is what it is, okay? And
Judge, respectfully, I'm not comfortable playing that if Ms. Link is not going to waive her appellate rights to that specific issue. I don't care about the first part coming in or her waiving there, but if there is a mention of we're going to read you your rights again, I'm not comfortable publishing that to the jury in any manner whatsoever. And the way I'm instructing Detective Jim Norris to limit that is, did Ms. Link approach you while you were fingerprinting her and explaining why she was being fingerprinted? Yes. What did Ms. Link say? Did you approach her? Did she approach you? She said, I didn't mean to kill him. Detective Jim Norris will say I said to Ms. Link, in order for us to talk to you, we have to go over your rights. And then I will discuss Miranda and discuss her waiving of Miranda and publish that portion of it. But I am not comfortable having any mention of again or anything like that, especially since we had a detective testify yesterday about Ms. Link not having to cooperate with law enforcement and objections sustained that were made by defense counsel about any kind of inference about her refusal to cooperate with law enforcement. I'm not comfortable, and I'm just not going to play it.
Understood. They'll play it with a waiver. And I still have to speak to Ms. Link about that. Are you agreeing?
So as far as to there being mention of the word again, yes, I will waive any appellate issues as it relates to that very specific part being played.
And are you in agreement with me that while it says again, and you have to go over your rights again, it's going to be the same form, the state is concerned that there may be an inference that there's a comment on her silence.
Right, so I'm waiving that specific appellate issue, yes.
Ms. Link, do you understand?
Yes.
So even though Mr. Tomas believes legally he can waive this, it really is up to you to decide if you're going to allow the state to play the full second interview, the portion we're talking about now, about police going over your rights again. So you understand that no one's going to tell the jury that you invoked the first time. No one's going to tell the jury that you invoked your right to remain silent. No one is going to comment on your silence but you're essentially agreeing that that is not going to be an issue for appellate purposes. Do you understand?
Yes.
You've had enough time to speak to us about that?
Yes.
Okay, do you need any more time to speak to him?
No.
Okay. Do you have any questions for me about what we just went over?
No.
All right. Okay, so I think you have a waiver.
Yeah, so I'll talk to Liz support about that later this afternoon when we actually publish that video and having that portion. There's a few other issues that I think are imperative to address. First and foremost, I walked outside, I made eye contact with one of the jurors, I recognized her, I said hello, I didn't realize who it was until I said that, and then there were a handful of witnesses around where the jury is, they're right outside the courtroom. I asked them all to just move away, so that way there'd be no...
That's right, well, I asked them virtually as well.
Yeah, they're right there. I just want to make everybody aware of that. The second issue is I want to make sure that we are not proceeding forward on any kind of suppression issue, because Ms. Lynn specifically said earlier that she was coerced into waiving Miranda, so she's going to be...
My understanding based on my conversation with her is she understands that no motion to suppress.
Right, I just want to make sure that that is also on the record. And then the third thing...
That's right.
Yes.
And then the third thing is, I spoke to Mr. Tomas about this. I spoke to Sergeant Crementini on my way into the office this morning. What he informed me was basically this. The phone extraction that is currently in evidence is the entirety of the phone extraction. However, that was done sometime about 2022. Sergeant Crementini, who was working with a team at the time, now has access to better technology. And very recently, within the last week or so, he decided to plug that phone in again and do the extraction again on his computer. Additional data was able to be read at that point in time. He called me this morning and informed me of that. I sent those text messages over to defense counsel this morning. The way he explained it to me was... No,
it sounds like I'm going to have to have purchase
right.
before late turning over the stuff.
Well, so yes and no, and I was going to suggest to the court that we do that, and that's why I'm kind of explaining it in the way I am. The way he explained it to me was this. Technology is ever changing. It's getting better, and as the technology gets better, the actual extraction itself is able to be read more fully by better technology. We now have better technology that is able to read that data and different data. The way he described it was basically like the DNA swab. DNA swabs get better over time. It's still the same blood, it's still the same DNA, however, you're able to read more. I sent over what he sent me today to defense counsel, which is a handful of text messages.
Please have a word to the jury all the way on the side, please. One man will communicate with me. You're too close to us, please.
Those text messages are between Ms. Link and somebody by the name or saved in her phone as Holy Smoke. Those text messages include references to shooting people, shooting Smoke's girlfriend, etc. As I said, and as the court indicated about the Richardson, I was going to successfully do one. I don't think it actually...
Why is Smoke's text messages relevant to you?
It's not. So that's what I was going to say. It's not a discovery violation because all that data still existed and was turned over. It's just a newer program that is able to read that data more. It's inadvertent because, again, we couldn't read it when this was actually turned over. It's prejudicial because it could affect Ms. Link's cross-examination or her testimony because she says in her statement, for example, that she didn't know anything about firearms, etc., but she's saying this to shoot other people. My remedy to it, I will not use it whatsoever, and it will be excluded entirely, and I'm going to direct Detective Crementini to discuss on his direct examination the betterment of technology over time, and if he has done anything recently, specifically about the videos on Ms. Link's phone.
So it's only relevant, the betterment of technology is only relevant about the videos on the phone?
Correct.
Have those been played?
One of them.
All right, is there something else that's going to be played?
Yes.
And do you have access to that, Mr. Tomas? You know what it is?
I'm not sure if there's any new information that I didn't already have.
So there's a few of them. There's the defendant and there is the defendant and the victim exiting the vehicle together, which I'm going to talk to him about the actual timestamp on Ms. Link's phone on that, which is somewhere in 10:30 time.
10:31, that's the day of the shooting?
The night before. So the shooting happens at like 3 a.m. they get outside of the vehicle, and which is corroborated by Ms. Langston's statement. There is a video that I plan on publishing later with the children, also them acting as a family, and then the actual shooting itself. I was planning on talking to him about the timestamps.
And these are all 1 or 2 days before the shooting?
This is the shooting, the night of the shooting. These have already been turned over, and what I'm going to ask Sergeant Cremencini is, were you able to verify the 2022 extraction to whatever you did recently? Are the videos changed in any way? And he will answer no. He will actually say exactly, I believe he said it was 861 videos that were on Miss Link's phone are the exact same from a few weeks ago to the day that it was extracted. There's no change whatsoever when it comes to the videos.
So, I guess just so the sufficiency of the investigation, they explain it that, which is why the testimony will come about recency and extraction of videos on the phone, even though they had it for 3 years.
So it sounds like, at least with the videos, I have all the videos already. The only difference is that they were able to get timestamps from within the data.
No, so if you look at my computer, I'll show you. So if you look at, and I know the court can't see it, but just for the purposes of the record, if you look on the actual Cellbrite report, which is what is furnished to me, the shooting occurs and there's a timestamp of when it was created at 6/25/2022, and there is a 6 minute and 57 second video. Part of that was published yesterday. It's created at 3:06 a.m. When this link is seen, it's about 6 minutes into the video. I'm going to have Sergeant Cremencini say, okay, if this is started at 3:06, that means that this occurred around 3:11, 3:12. Then I'm going to show him the call log of the defendant with the 911, showing that 911 was called around 3:21 a.m. All of this has already been in defense counsel's possession. Nothing with regards to the video has changed whatsoever. The only difference is that the technology changed so that we can better read information, and these text messages that were now being able to be read were now furnished to defense counsel. I do not intend to use them whatsoever. I wanted to make sure that that was on the record, that I am giving the remedy of that exclusion of that evidence, regardless of
and the few that you want to play, because you already said that she came looking for him at, what's his name, Brian, what?
Kevin Bonilla.
Kevin Bonilla's house. It goes hand in hand, that they were getting along.
Correct.
Until the time of shooting.
Yes.
So it sounds like it's relevant.
So I don't have a problem with the better being able to pinpoint the time that the videos happened based on this new data. That's fine.
No. The extraction that I have. This is from 2022. Nothing has changed. What I'm talking about, the data being better and the extraction being better, solely goes to the text messages. I'm just going to ask Sergeant Cremencini, did you confirm when you got better technology? Were you able to confirm that the videos that were extracted are exactly the same? There's no additional videos or anything like that.
So, Judge, my only concern would be bringing in text messages or anything else that I hadn't seen up until now, but it sounds like they're not doing that.
That's correct.
Then there's no problem.
Right.
You have to be careful with the word confirm. That's a conclusion, right? Why don't you ask him?
Well, he can, because number one, he's an expert. Number two, he will and can testify about hash marks and how you can confirm that the same data that is on the phone then is the same data that's on now. He will say they're the exact same hash marks.
So what? So you will start out by asking him, what's the date, whatever hash mark on this item versus this item, and then he can say factually that they're the same.
Yes.
And then you can ask them, do you confirm that they're the same?
Yes.
Do you understand why
I do.
I'm concerned?
I do.
You just saying this and this, are they the same? Did you confirm?
No, I'm going to lay significant predicates before I even get into that. And we can also go sidebar to make sure, or voir dire him outside the presence of the jury to make sure that everything that we do is in the correct way, so that way there are no issues later on.
I think we've taken care of what we're supposed to take care of before these next witnesses testify.
Yes, ma'am.
Who's going to be the first one?
We're recalling Detective Zapata. Sorry.
All right, so can I start?
Yes, sir.
You will bring the jury. There we go. A lot of fighting, some waving of rights, a rescan of the defendant's cell phone, though it's turned up some more text messages than the first scan. Those messages include smoking someone's girlfriend, but he's not going to use those. This is it's a little bit crazy. So it's nearly 11 o'clock and we're just getting started with this one. We are expecting the state to rest today, probably this afternoon. I think the first witness that comes in is a recall, where they're just going to admit a few pictures they forgot to admit through him previously.
Yeah, I'm not sure which witness.
Greg, can I,
Look how narrow that space is. That limited space for them to go in and out right there is most likely both a fire hazard, an OSHA violation, and an ADA compliance issue.
Yeah, I'm moving that.
Camera.
All right,
Shoes. Okay, let's name the shoes as they pass. I think we start with Converse again. Converse. I can't see those ones. Nike. Basic. Don't know. Reebok, maybe. And I think those are Skechers. Those are bailiff Skechers, if I've ever seen them.
Sorry for the delay. This is my fault. I blame all the police on the news is the witnesses are outside. We're ready to go. The state's going to call the next witness.
Yes, Judge. At this time, the state calls Detective Zapata.
Just calling Detective Zapata.
Judge, permission to reposition the podium?
Yes.
The court clerk is the busiest person in this courtroom, and unfortunately his table has like a very sensitive microphone. So most of the banging and paper shuffling is his fault. She's back.
You're still under oath from the last time you testified. So we're not going to swear you again, but you're still under oath.
Okay. Good morning, Detective Zapata. Good morning. Detective, I want to go back to photos you took from the scene when you arrived June 25th, 2022.
Okay.
You mentioned in your testimony that you photographed a vehicle.
That's correct.
I want to focus on the vehicle that was in the alleyway. What kind of vehicle was that?
It's a silver SUV.
And did that vehicle have blood on it?
Yes, it did.
And did you also review photo vehicle was in?
We're having some issues on the... Let's see if we can get this fixed. Just notice how many pens are on the judge's desk up there. that the witness appears to be looking at.
Judge, I now move into evidence based on stipulation by the parties, what has been previously marked as 1T and 1V. 1U, sorry, Judge.
Yes.
Say Exhibit 1T marked for identification now becomes Say Exhibit 17, and 1U marked for identification now becomes Say Exhibit 18.
Permission to publish, Judge.
It's because we called him out on it. The stapler was removed. Is the lotion gone? This little stack of Post-it notes.
Now, Detective, where is it that you photographed that there was blood on this vehicle?
That's on the exterior of the driver's door.
This is the Elmo projector.
Yes,
On the driver's side door?
that's correct.
I also want to show you, is this when the vehicle was taken in?
Yes.
Did you seal off the vehicle, Detective, when you got to the scene?
Yes, I did.
And what is here in the driver's side of the vehicle?
On the driver's side, on the driver's seat of the vehicle, you have a few items, such as a set of keys, blood-stained money, a blood-stained cell phone, and I believe a blood-stained piece of paper, maybe a check.
Where was there also blood-stained money when you photographed in the alleyway? Where was also money?
There was also a blood-stained bill on the alleyway, pretty close to where the victim was located.
And were these the items that were located in the driver's side of the vehicle, Detective?
Excuse me. Yes, those are the items.
And this credit card, whose name is on it?
The victim, Pedro Jimenez Gonzalez.
I want to go back to this photo right here, Detective. Can we see what's on the passenger side?
Yes, that is a blue tank top.
Is that this same tank top that's here?
That's correct.
Would you say that that is a woman's tank top or a men's tank top?
Woman.
Hold on, stop. It's the same. She's gonna ask another question.
She already said woman.
What about this type of clothing? Was that also found in the car?
Yes.
And based on your experience, Detective, do you know whether what clothes can be men clothes or women clothes?
Yes, I do.
What would you say these types of clothes are?
She actually calls her speculation.
It's the same. She's gonna ask another question.
Now, Detective, I want to go back to the blood trails for a moment. Did you have a chance to accurately and thoroughly review your report?
Yes, I did.
When you reviewed that report, Detective, did you document when the blood trails first started, where they first started?
Hold on a second.
Apparently, we've got a sidebar. Got a sidebar happening. What I found interesting that the defense in the background was having what looked to be a very animated conversation from the defendant to her lawyer as he was listening in and she was explaining something using a lot of hand gestures, quite, emphatically. And in the midst of that, we've got the prosecution asking the detective, is this a man's shirt or a woman's shirt? And he's like, objection, which means he either is really good at listening to two things at once, and being a guy, I don't think he is. But he's probably not listening to his client right now. He's focusing on the question, but still wanting to act like he's interested in what she's saying. He was following that questioning very, very closely. He squeezed that objection in. The witness still answered and said women's, which she was not supposed to do, but I thought that was just a little funny how that timing worked out. Do we need an expert fashion witness? Yes, we do. Let's see. My hubby does that daily. I know I do have the ability, and Mrs. R.A. will probably testify to this, to basically have like a mental body cam, like an audio video recount for the last 15 seconds. If you stop me at any time and say, what happened, in the last 15 seconds, I can tell you the words that were said, even if I was not listening. So I can be watching a video on YouTube or something, and my wife can be talking to me, as the case might be, and she's like, are you even listening? And I can say, yeah, you just said.
About that. So the suspect blood trail, after you reviewed your report, where did the suspect blood trail first start?
The blood trail appeared to have first started in front of the residence. In front of the residence, there's another set of duplex. In front of that duplex and on a concrete walk path near a tree is where I first noticed the set of apparent blood.
And I'm now publishing what's been admitted to evidence as Stage 18. Now, detective, when you say the front of the house, so is this the house, the defendant and victim's house?
Yes.
And when you say the front of the house, are you indicating somewhere in this area where this silver car is behind this tree?
Yes.
So based on your report, was there a blood trail, suspect blood trail, right in front of the doorsteps of the victim and defendant's house?
No.
Moment to confer, Judge. Sure.
Witness manages to remember to use the term apparent blood instead of where the blood trail started. She's supposed to say apparent blood every time she says it because they have not tested it, or she did not test it to see if it was blood. That's somebody else that does that. We did this before. They're trying to, I guess, solidify or clarify some of her testimony. And they did just get a few more pictures in of the vehicle. Where
Detective Zapata, was mail also found in the car when it was impounded?
I'm sorry, can you repeat the question?
Was mail, a piece of mail, also found in the car when it was impounded?
Yes, that's correct.
If I were to show you that, would you recognize it?
Yes.
Judge, I now move into evidence based on stipulation by the parties what's been previously marked as States 1V.
State Exhibit 1V, marked for identification, now becomes State Exhibit 19.
Permission to publish, Judge.
What are you doing to the camera? That is not an Elmo. Quit breaking it. It was working fine before.
Now, detective, is this the piece of mail you saw?
Yes.
Whose names are on the piece of mail? Permission to approach the witness, Judge.
The names are Pedro Jimenez and Daisy Blink.
And what address is there?
The address is 956 North.
No further questions, Judge. Any cross-examination for officers about that?
Yes, Your Honor, just a moment. Judge, before I start with her, by way of stipulation, I would ask that what's marked as Defense Exhibit A1 be admitted into evidence.
Defense Exhibit A1, marked for identification, now becomes Defense Exhibit A.
I got a stubby little pencil. He does sound
So,
like Mr.
ma'am,
Frog.
we spoke yesterday. I'm going to show you this again. I'm showing you what is
6. Number
already in
state
evidence
6.
as State's Exhibit
6. Trust me on this one. It's 6. Told you. Hunt off your back porches. Sounds like fun. Though you don't need a tree stand. You don't have to go in the woods. You just.
Now, this is the home in question, correct?
Yes.
And you are the person who drew this red line yesterday, is that correct?
I'm sorry, can you go back to the first question?
To the first question?
Yes. Your first statement about the residence?
The home where Daisy Link lived.
Yes.
Is this the home? Would it be easier?
Yes, sorry.
Okay. 1 minute.
Yes.
This is Daisy Link's home, right? What I'm pointing to right here.
If I'm not mistaken, this is still.
Oh, this one. Okay. So I'm going to show this to you real quick. But you see the line that you are the person who drew this red line, correct?
Yes.
And you would agree that it's a little hard to see because it's red, but right here, you drew a line that came all the way here, right to this area, which is where the front door of the residence would be. Is that correct?
I'm sorry. Yes, here.
Yeah, and you can see the little line going here, right?
It's not a touchscreen TV.
Yes, there's a line there.
Yes. And, okay, I think I should have this with one. So as we spoke yesterday, by way of reminder, there was you also drew a line over here, this area here, this area over here, but there was no blood in this specific area right here. Is that
Correct. That line was to show the alleyway.
Okay. The blood was on the other side, which is over here where all this is, right?
Yes, there was blood leading up to where the victim was found collapsed.
And as far as your investigation goes and what you were able to determine, the blood trail began in this area here, in this general area here where this line starts. Is that correct?
Further, I don't recall the direction, but further, because of the trees, you can't really see the concrete walk path, but it's more so towards the front where there's a tree. You can't really see it in the picture. So it's in front of the residence, not so in front, but in front of the residence and in front of the duplex, where you see the bushes of trees, that's where the blood appeared to have started.
So just to be clear, the blood trail appears to start near the front door of that residence?
No.
Okay, how far away from the front door of the residence is it?
I would say if I'm standing...
From me to you?
If I'm standing in front of the residence, approximately maybe 15 steps, maybe, approximately.
Okay, so maybe a little bit less the distance between me and you right now?
I would say a little bit more, maybe.
15 steps is further away than I am from you?
I don't know, I'm giving you an approximate. I can stand up and walk toward and count.
Well, 15 steps, right?
Approximately, could be more.
Could be more, could be less too, right? You're not certain?
Correct.
So other than the items that other than the items that you discussed a few minutes ago, Mr. Jimenez's license and some other cards and wallet were found also. Is that correct?
I would have to take a look at the photos.
Sure. Judge, if I may approach, I'm going to show you what's marked as Defense Exhibit 1.
There's a standing.
Does that appear to you to be the license of, well, actually 2 licenses of Mr. Jimenez? There's 3 pages there if you want to take a look.
Yes, it says his name on them.
And there's 2 of them, right?
Yes.
Do both those licenses have the same address?
Yes.
And what address is that?
956 Northwest 4th.
Not the address where Daisy Link lived on the day in question, correct?
It is not the same address.
No further questions?
Yes, please.
Judge, permission to approach? Ms. Sabata, is the address that was listed on Mr. Jimenez's license to your left the same address that was listed on the mail that was found in the rental car to your right?
Yes, it is.
And does that mail also have Daisy Link's name on it?
Yes, it does.
And was this mail found in the car that Ms. Link was driving the night the victim was shot?
That's correct.
There calls for speculation as to Ms. Link was driving the car that night.
It's the same. You want to ask a question?
Yes, Judge. Is that the same car that was found on the scene next to the victim's body in the alleyway the night he was shot?
That is.
No further questions, Judge.
The next witness will be
Dr. Mathis.
Dr. Mathis.
I'm scared to ask anyone to go to this courtroom. They might end up in jail for contempt of court for not smiling the way the judge liked.
Raise your hand, please. We sworn to our friend that testimony about to give the truth, the whole truth, and nothing but the truth.
I do.
Morning. Sorry, 5 seconds with your.
That's one call I have not yet gotten on received on my burner phone. It was a call to bail one of the viewers out. Don't even know how I would do that. We'll tell you while they're doing sidebar. The surprise I got in the mail was actually something I purchased myself. It's an old video projector. I say old because it was used. I actually used this exact model at another venue that I did a gig at, and I liked it. And so when I saw it was for sale on eBay for $100, I picked it up because I knew they were like $1,800, and I didn't want to pay that. So it's a Epson. It's got all the HDMI, every type of input, audio pass-through, built-in speaker, keystone correction, 3 LCD projector. We're going to use this for Halloween. So It's going to be projecting the wanted poster up on the sheet out in front of the house.
Projector, so maybe so.
Is she talking about my projector? It's a good one. Just know if you need to get bailed out, you're going to have to wait like at least 24 hours because we'll have to do like a little fundraiser in chat. We'll put it to the audience to see if they want to raise your bail or not. Seriously, just sidebar after sidebar. So you might serve it, an extra day or two in chat, and then, well, it'll actually be a little bit longer because after the funds are raised, it takes till the 21st of the following month for YouTube to give me the money. So bail will be a little slow. You might sit for maybe tops like 30 days, okay? And that's if chat decides that you're bail worthy. So I mean that is an option, but just know that if it's a large bail, I mean, we're talking 10%, right? It's got to be 10%. It's got to be reasonable. So if it's a large bail, you're probably guilty anyway, and we're just going to let you rot. No, just kidding. You're not guilty. We'll just let you rot anyway. John Davenport, member for 31 months. This judge and the court have more sidebars than Karen's trial combined. There seem to be a lot. Yes, we will be streaming on Halloween the trick-or-treating. It's going to be a lot of fun. That way, this is a business expense. These have a defect where one of the internal optical pieces goes out of alignment, producing pink and blue brands on the top and the bottom. There's instructions on the line to fix it. Oh, we're talking about the prism? So I actually used to buy those prisms, which are really cool because you can shine light through it and it'll split it 3 different ways. So it can break the color down. It's really cool.
The stipulation I'm going into, there is a stipulation between the parties that the body autopsy under medical examiner case number 2022-1959 is the body of Pedro Jimenez. In other words, the legal identity of Pedro Jimenez has been established by stipulation of the parties. You can start questioning Dr. Mathis.
Yes, Judge. Good morning. Can you please state your name for the record?
Good morning. I'm Dr. Benjamin Mathis.
Mr. Mathis, what do you do for a living?
I am the Chief Medical Examiner of the Miami-Dade County Medical
Here comes the
Examiner
Emmy.
Department.
John, you're an
How long
OG.
have you been the Chief Medical Examiner?
10 days. Last week, they promoted me to Chief Medical Examiner. I've been Deputy Chief for the prior 3 years.
Congratulations.
Thank you.
So you mentioned you've been Deputy Chief for 13 years.
I've been at the Medical Examiner Department for 13 years. The last 3 were Deputy Chief.
And can you tell the jury a little bit about your education and training in forensic pathology?
Sure. I went to Brown University in Providence, Rhode Island for my undergraduate degree in Classics Latin. And then I stayed at Brown for medical school where I graduated with a Doctor of Medicine degree. Then I went to the University of Pennsylvania in Philadelphia for my residency in pathology, anatomic pathology, and clinical pathology. After completing the residency, I came to Miami for a fellowship to subspecialize in the subspecialty of forensic pathology.
And are you board certified in forensic pathology?
I am.
About how many autopsies, Dr. Mathis, have you performed over your career?
Around 2,000.
And have you previously come to court to testify as to the cause of death of an individual?
Yes.
About how many times have you done that?
Several dozen times. I usually come about 10 times a year. 10 times a year times 12 years, 13 years I've been here.
And were you qualified as an expert on each of those occasions that you came to testify?
I have.
In what field were you qualified as an expert?
Forensic pathology.
Now, Dr. Mathis, can you tell the jury what exactly a medical examiner does?
Sure. A medical examiner is a forensic pathologist who works for the government generally, And we're charged with investigating deaths of individuals who died either under circumstances or because of who they are that the state has an interest in. So all non-natural deaths will go to a medical examiner, accidents, suicides, potential homicides, drug overdoses, inmates from the prison, those who die in police custody. And then when we investigate their deaths, we need to determine the cause of death, what caused them to die, and the manner of death, which is how we classify their death. We'll perform whatever investigations or studies we need to do, whether it's a record review, looking at their medical records, to performing a full autopsy, performing special dissections, having special tests run, studies done, also that we can determine what the cause and manner of death is.
And were you working as a medical examiner for Miami-Dade County on June 25th, 2022?
I was.
Are you the original medical examiner who did the actual autopsy on the victim, Pedro Jimenez?
Yes.
So I want to talk about your involvement in this case, Dr. Mathis. When did you perform that autopsy?
June 26, 2022.
Where did you perform it?
At our office, it's a medical examiner department. It's right across the street from Ryder Trauma at Jackson Medical Center next to Miami-Dade College Health Campus.
And when the body arrived for autopsy, what was its general condition?
He was in a fresh state. He had soiling from blood staining on his legs.
And did you observe any signs of medical intervention, such as bandages, anything like that on the body?
Yes, he had a tourniquet on his right thigh.
Now, can you walk us through the steps you take when performing an autopsy, Dr. Mathis?
Sure. So first, we capture the height and weight. We'll take a receiving photo of the individual. Then, if it's a suspected homicide, we'll get pictures of the hands. Then we'll collect fingernail clippings as evidence. The body will then be washed. We'll take photographs, overall photographs of the individual. And then if there are any tattoos or injuries, we'll take photographs of those. Once the photographs have been taken, then the doctor will take any written notes about the external appearances of the body, of the tattoos, of the injuries. And then at that point, an internal examination, or what people colloquially call the autopsy, will begin to be performed.
So you mentioned a lot of steps there.
Yes.
So I want to break that down. Can you explain to the members of the jury what an external exam is?
Sure. So external exam sounds just like that. We're taking note of the external features of the body. First is the routine. Their body size, their body habitus, their height, their weight, their eye color, their hair color. And then we will, after all the regular stuff has been documented, then we'll turn toward tattoos and scars. And then then we'll move into injuries. If there are any external evidence of injuries, then we'll document those down as well.
So you mentioned that you document tattoos. Did the victim in this case have a lot of tattoos?
He did.
And was one of those tattoos the name Daisy?
Yes.
Now, you also mentioned you start with external injuries. So I want to talk about those. What external injuries did you observe on the victim's body in this case?
Yes, so he had a through and through gunshot wound on his right thigh and a through and through gunshot wound on his left foot.
Now, Dr. Mathis, you mentioned a through and through gunshot wound through the right thigh and left foot.
Yes.
Wow.
So I want to break that down. I want to start with the left foot.
Hit both legs.
Your Honor, I now move into evidence what has been previously marked as states 1W by stipulation of the parties.
State Exhibit 1W, marked for identification, now becomes State Exhibit 20.
While we're having this testimony in chat, if you'd like to list any autopsy-appropriate songs in chat that you think would be appropriate to listen to during an autopsy, that would be great.
It is.
Now, you mentioned that he had a through and through gunshot.
Yes. Can I come down? I don't have my glasses.
Can you show to the members of the jury where the entrance wound is on this foot?
It may be hard for you to see as well, but the entrance wound is on the bottom of the left heel.
And how do you know it's the entrance wound?
So, in general, entrance wounds are round. They can have a rim of abrasion. In this case, though, its skin is different than the rest of the skin on the body. Regular skin, a lot of it has hair. Foot skin, the plantar skin, the skin on the bottom of the foot, it's thicker, it's more elastic than the rest of the body. Anybody who's done a foot rub can attest to it or had to remove a splinter. So when a bullet goes through the skin of the sole of the foot, the plantar skin, the tissue is very elastic, so it will retract, allow the bullet to come in. So when you have an entrance wound on a bottom of the foot, you're going to see more of a slit-like appearance. In this case, you can even see a halo where the bullet tunneled in, but the skin retracts after it, and it's just the nature of the skin on the bottom of the foot.
And in this picture, where is the exit wound?
The exit wound is on the Achilles tendon region on the back of the heel.
How do you know that's the exit wound?
Exit wounds are irregular. Oftentimes you can take them and push them together, the edges together. You can see that this has a kind of slit-like irregularity to it, and that the pieces fit together like a puzzle.
And now, Dr. Mathis, looking at the entrance and exit wound, can you determine the path the bullet took when it entered the foot?
Yeah, so since this is the entrance wound, that's where it's entered. It's what we call a perforating wound. So it's entering through the sole of the foot, the left heel, and it is going through the soft tissue and coming out the back of the heel region of the Achilles tendon region.
Now, Dr. Mathis, you also mentioned that the foot is flat and it has tougher skin, is that right?
The sole of the foot, yes.
Would a person wearing a shoe, would that move the path of the bullet when it enters the person's foot?
Move the path of the bullet. So sometimes when you're wearing clothing or shoes, it can change the appearance of the entrance wound. It can add irregularity to it. It can also help us to confirm what we're seeing. So if you're looking at this or you're less experienced and you don't have a lot of experience looking at plantar wounds on the bottom of the foot, you can look at the clothing and or the shoe, and you can interpret the directionality from the shoe or the clothing itself.
And what is this photo here?
That's a close-up of the exit wound on the back of the heel on the Achilles tendon region.
I'm sorry, it's an Achilles.
Achilles tendon region, the back of the heel.
And how do we know that's the exit wound?
It has all the features of an exit wound. So you can see the skin kind of fits back together with a puzzle piece. If I push the edges together, it has an irregular linear. It's kind of linear, but it's irregular. That makes the features of an exit wound.
And what about this photo?
That is a close-up of the entrance wound on the bottom of the foot.
And how do we know that?
Because of the way it looks. So, like I said, normally an entrance wound is going to be round, but because of where the location is on the sole of the foot and the nature of the skin down there, entrance wounds on plantar surface can look linear. The bullet just kind of separates the tissue, comes in, and the tissue collapses behind it.
Now I want to go back to, you mentioned shoes, and that can change the shape or irregularity of a wound. Was the victim in this case wearing shoes, do you know?
Yes.
Did you receive those shoes?
I did.
What kind of shoes were they?
They're like a boot, casual boot.
Judge,
We're going to need the brand.
I now move into evidence what has been previously marked as states 1X.
Are these like Tony Lamas, or are we talking like Keen, a hiking boot? Is he wearing some Merrells? Is this a steel-toed work boot? Maybe like a Red Wing?
By stipulation of the parties, Judge.
All about shoes, guys.
Stay Exhibit 1X marked for identification now becomes Stay Exhibit 21.
Some Timberlands.
Permission to publish, Judge?
Yes.
Dr. Mathis, are these the shoes that you received from the victim
Man, I wish we
that were recovered from the victim's body?
Yes. They came with them.
And what are we looking at here with the white, where the white stick is pointing?
So there is a hole next to the white stick. This is the outer edge of the left heel region of the shoe. And then below it, you have red discoloration, which looks like blood to me. This is just a further out photograph, so you can see the entire shoe.
What's interesting about this picture, Dr. Mathis?
So this is the back of the shoe, and if you recall the wound I kept referring to as on the Achilles tendon on the back of the foot, this is correlates with it. This is where it came out from. So it came out of the skin, and then it came out of the shoe, creating this irregular defect here.
So that's where the exit wound came out of?
Yes.
And where was this, what part, is this the entrance or exit wound entry?
This is the entrance wound. You can see the fibers of the fabric or leather are pointing inward, and it's creating a defect.
It's leather.
That's consistent with entrance wound from clothing.
Now, you also mentioned that in this case, the victim had a wound to the left foot and a wound to the right thigh.
That's correct.
I want to talk about the wound to the right thigh. Judge, I now move into evidence what has been previously marked as 1Y by stipulation of the parties.
Stay Exhibit 1Y marked for identification now becomes Stay Exhibit 22, Judge.
Something from Walmart. That's a Walmart brand shoe. I'll show you the demonstration. Basically, he was running and
Now, Dr. Mathis, is this the wound on the right thigh?
he had his
Yes.
left leg
So what
up.
you're looking at here is
And he got shot through the heel.
his belly on our autopsy table. So you're looking at the back of his lower extremities, back of his leg. His buttock would be here, right above where the picture cuts off.
And is the wound to the right thigh, did it have both an entrance and exit wound?
It has both an entrance and an exit.
And this wound is the entrance?
Is the entrance.
How do we know that for the right thigh?
Because of the way it looks. Sorry. Because of the way it looks. We interpret gunshot wounds, entrance, exit, based on their morphology, the way they look. And this one.
Did he just tell a joke? How do we know it was a bullet?
This one,
Because of the way it
you can
looks.
see from this view, better closer up, but you can see from this view, it's nice, and it has a round that's punched out appearance to it.
Now, what are we looking at now?
Now, this you're looking, he's lying on his back now. And up here above, that would be the groin region above, and it will be down from the top of the thighs down. And within the tattoo, there is a gunshot wound there.
Is this a better view of the front of the victim's thigh?
Yes.
And what exit wound is that?
That is the exit wound. That's on the front of the thigh, and that's the exit wound. Same thing, just a different orientation.
What about this picture?
So now we're back on the back of the thigh. This is an entrance wound. You can see it has a punched out appearance. You can see the yellow in the middle, that's the fat, the soft tissue underneath the skin. So that's missing, that's the German gunshot. You can see it's got like this oval, it can be round, it can be oval, it can be elliptical, depending on the angle that they go in. Going around the wound. And then you see that there is what we call abrasion, some scraping of the tissue around the edges of the wound. These are all features of an entrance wound.
Now, Dr. Mathis, for his right thigh, were you able to determine the path the bullet was taking?
Yes, so this is the entrance wound, it's on the back of the thigh, so it's going from the back to front.
Is the way that the bullet entered through the back of his right thigh consistent with the victim facing his back to the person who shot him?
The back of the victim needs to be facing the barrel of the gun.
So yes.
Yes.
Would it be consistent if you were facing the person who shot him?
No, because the barrel of the gun has to be pointing toward the back of the thigh.
Now, Judge, I now move to evidence what has been previously marked as stage 1Z by stipulation of the parties.
Stay Exhibit 1Z, marked for identification, now becomes Stay Exhibit 23, Judge.
Judge, permission to publish? Yes. Now, Dr. Mathis, what are we looking at here?
We're looking at the student's lying flat on his back on the autopsy table, and I took plastic probes and ran them through, placed them through the pathways of the two gunshot.
So this is the wound to the foot.
Correct. And now it kind of makes more sense when you saw the shoe and how it looked on him. Harder to appreciate when you're just seeing the whole stuff. With the probe, it makes it easier to visualize.
Now, Dr. Mathis, I want to take everything together, what you said. We spoke about the left foot, the path of the bullet. We spoke about the right thigh and the path of that. Judge, I now move into evidence what has been previously marked as 1K by stipulation of the parties.
Stay Exhibit 1K, marked for identification, now becomes Stay Exhibit 24, Judge.
Judge, permission for the witness and myself to stand over here? Now, Dr. Mathis, can you explain to the jury what this diagram is indicating?
Sure. So this diagram here in the middle is the notes I take during the autopsy. We call it a body diagram sheet, and that's where I'm marking down his hair color, our tattoos, and then I noted where the wounds were, what their size is.
And how did the bullet first enter the body?
How did the bullet first enter the body? So he has an entrance wound on the left foot. That's coming out the back of the left heel region, and he has an entrance wound on the right thigh in the back that's coming out the front of the right thigh.
How is it possible that the way the bullet entered, how is it possible with that angle? How would the victim have had to have been standing for the bullet to enter the way it did?
From the bottom of the foot?
Yes.
So that's bottom of the foot. So to get an entrance wound on the bottom of the foot, the gun has to be under the foot. So if the foot is on the ground, it has to be, I guess, on the upper floor and coming through the ceiling, or the foot has to be in the air in order for it to get go in. So since that scenario doesn't really make sense, the left foot needs to be up in the air in order for it to be facing the barrel of the gun.
Could that be consistent with if the victim was going to try to run, that his foot was up? Would that be consistent?
Yes.
Now, once the bullet enters the left foot and exit, where does it go?
So then it comes out the back of the left foot.
And then where does it go?
Then it's going to continue in the same trajectory along a straight line until it hits something else.
And then can you just...
Or just drop to the ground.
And then for the thigh, can you talk about how when it left the foot and it enters the thigh, how that's possible?
So, yes. So the same bullet can cause both wounds. It can go from the outer edge of the left foot, the left heel, to the back of the left heel region. And then the foot's up in the air, it can go into the back of the right thigh and out the front. So it goes through the foot and then through the back of the thigh and out the front.
And you're indicating that the record reflects that the witness had his left foot up and his front was facing the judge.
Right, so your right leg has to be forward, your left foot is up, and you could create that pathway.
And your back has to be facing the person who's shooting.
Yes, the back of the foot, yes, but that's where it has to come inside.
Now, Dr. Mathis, looking at the wound tracks, is it possible that a single projectile did this?
Yes, in the way that I just described.
And okay, we're good. Now I want to talk about the internal examination.
So loud.
Did you perform an internal examination?
I did.
He's not comfortable.
And what internal damage did you observe as a result of the gunshot wounds?
So inside the body, his organs, those were all good. I had to do a special dissection on his right thigh to document the injuries going on within the soft tissue. And he had a lot of blood and bleeding in the muscles of his right thigh, in the region of that gunshot wound. And he had holes in his femoral artery and femoral vein.
You mentioned he had holes in his femoral artery and vein. Did the bullet strike or sever those major arteries?
Yes, the bullet struck those arteries.
And now, Dr. Mathis, based on your expertise and experience, would an injury to the femoral artery, such as a gunshot wound, cause rapid or severe blood loss to someone?
It will cause severe blood loss. The blood comes from the heart, is pumping. The femoral artery comes off after the aorta branches into the iliacs. The femoral artery is one of the branches that comes off the iliac artery, and it supplies blood flow to the rest of the leg. So it's a very important blood vessel, and it will bleed, and you will lose a lot of blood from it.
And are you able to estimate about how quickly a person can lose consciousness or die from such bleeding?
So when we're talking about a femoral artery, it will take longer than, say, if you have a hole in your aorta or a hole in your lung or a hole in your heart. It's a bit downstream. So it can take several minutes, and then there are things that can mitigate it. If you're applying pressure, or if for some reason the muscle tissue is compressed around the wound, anything that's going to apply pressure to that area can slow down the bleeding.
Now, you also mentioned that several things can mitigate that. Let's say, Dr. Mathis, that there was no mitigation. There was no covering or trying to prevent the blood loss. If pressure is not being applied correctly, how fast would the victim take to die from this type of wound?
It can still take several minutes.
And is based on your knowledge, was that consistent with what happened to the victim in this case?
I don't think there was a long survivability period, but I wasn't aware of that at the time of the autopsy. For us, it didn't matter, but it will take. It's not going to be that you're shot and you suddenly collapse. There is a time period where it will take for the blood to come out of the body, reduce the blood volume so that the heart no longer has enough blood to pump up to the brain to give it the oxygen it needs.
And how is it that the blood is going to come out the body? Is it going to come out rapidly? Is it going to splatter a lot?
Yes, so you have both an arterial bleed and a venous bleed. So the vein is returning blood from the bottom of the foot. That's a low pressure system. It will ooze, or it'll accumulate in the muscular tissue. The artery, on the other hand, each time the heart pumps, blood is going to be spurting out of that artery. If that artery has a clear path out the hole, the exit hole, then you will get blood coming out of that hole, and that's where you see, like in the movies, the arterial spread. If there's not a clear pathway from the hole in the artery because it's blocked by muscle or tissue, then it'll continue to spurt, but it'll come out, it may not come out as a spurt out of the hole when it leaks. It may accumulate in the tissues and then dribble out.
Now I want to talk about toxicology. Was a toxicology test performed on the victim?
Yes.
And what were the results of that test, Dr. Mathis?
Okay, I'm just referencing the toxicology report. So in him was detected ethanol, which is beverage alcohol like you'd find in vodka or tequila. He had cocaine. He had metabolites of cocaine, the breakdown products. and he had THC, which is the active ingredient in marijuana.
And how much cocaine was detected in his blood?
He had, according to the report, 0.274 milligrams per liter.
Would you say that's a lot of cocaine, Dr. Mathis? A little bit of cocaine?
It's a healthy amount of cocaine.
And now, based on your experience, Dr.
healthy
Mathis,
amount?
what is it that cocaine does to the body or blood?
So cocaine is a stimulant. So it causes your heart to increase. It will increase your blood pressure. It narrows the blood vessels. That's how it increases the blood pressure. And like I said, makes your heart race. It keeps you. It's an upper.
Based on your exam, Dr. Mathis, did the cocaine contribute to the victim's death?
No,
Why do you say that?
because he's got a gunshot wound that went through his femoral artery and he's bleeding out, dying from hemorrhagic shock.
Did any of the substances that he had in his blood system contribute to his death?
No.
So I want to talk about the cause and manner of death. Based on your examination, were you able to determine the cause of death?
Yes.
What was it?
That was the gunshot wound of the right thigh.
So how long would it have been, Dr. Mathis, based on your training and experience, it would take someone to bleed out or die from that injury?
Like I said, it can take several minutes.
Were you able to determine the manner of death?
Yes.
What was the manner of death?
Homicide.
Moment to confer, Judge.
So we have a skeleton model we can show this on. But basically, the skeleton, if he faces away from you, this would be his left leg in a running position. The ankle is up, the foot's in the air. He was shot in through the bottom of his foot and out the top by his Achilles, and then the bullet traveled through his thigh on the other leg. So that's how one bullet has an entrance, an exit, an entrance, and an exit wound. The only thing I didn't quite understand is how the bullet appears to be going up on the thigh. So it enters high, or enters low and exits higher. Is that what I understood?
Dr. Mathis, I want to go back to the external injuries you observed.
Yes.
If the victim was running away, I'm doing this.
Yes.
He's running with his left foot up. If he's doing this, is that consistent with what the shot that you observed, the wounds you observed on his body?
If he's in a running position, yes. The left foot has to be in the air and the right foot has to be forward.
So if he's running away, that's consistent?
Yes.
Okay.
It must be lower.
Now, I want to talk about ricocheting.
For the right
Is
foot
it
has to be
possible
forward.
that the person who shot the victim shot into the ground and that it went through his left foot and out through his left thigh? Is that possible with what you saw here?
I find that extremely unlikely. So when you have a ricochet, when you first fire the weapon, it has all the energy in it. That's why it can make characteristic appearances of gunshot wounds. In this case, the bullet not only went through the shoe, the boot, twice, went in and went out, went through the foot, went through the thigh, in, and came out. That takes a lot of energy. So ricochet's, one, not going to be able to do that, and two, the wound on the back of the thigh would have had to have, if it managed to even get out of the left shoe, which I find very unlikely, that you would have a ricochet that actually can go through the shoe, go through the foot, come out the shoe. When it hits that right thigh, it's not going to have that nice,
this is the better
that
argument.
nice oval wound that you saw. So I can't see this being a ricochet. No.
Now I want to talk about again the arteries that were damaged. Is a time delay in the time from the time that the victim was shot, if there was a time delay in calling 911 or having assistance, would that also likely contribute to his death?
So when you have a wound like that, those are devastating injuries that require immediate medical attention. The wound needs to the blood flow needs to be stopped. Basically, you need to put a tourniquet tight around the wound to stop the blood flow into the leg. And then, of course, you're on a clock because the leg's not getting the nutrients it needs, and you would have to amputate. But a femoral artery wound is a devastating injury. So yes, if you don't receive medical attention, you will die quicker.
So if there was a delay in calling 911 or getting assistance or putting a tourniquet on the victim, that's going to speed up the time he dies.
Yes.
Now I want to talk about the drugs in his system.
Yes.
I know you mentioned earlier that those didn't contribute to his death.
Correct.
Would you say, doctor, based on your training and experience, that the drugs slowed down the amount of time it took him to die?
So there are some people who would say, okay, cocaine is a stimulant. So a lot of times when people get shot, they get an adrenaline rush. They may not even feel that they were shot till they look down and they see that they are bleeding. That adrenaline rush, adrenaline is also a stimulant, also causes the heart to beat faster and the blood vessels to constrict, which will increase your pressure. So cocaine as a stimulant could, in fact, actually help the situation because it's causing the blood vessels to be more constricted than they ordinarily would be, which is going to increase his blood pressure, which could theoretically increase his survivability period. But you still have a big hole in your femoral artery, so.
Thank you. Moment to defer, Judge. No further questions, Judge.
I don't think the energy of the bullet argument was nearly as persuasive as the uniform nature of the entrance wound after a ricochet is extremely unlikely. A ricochet typically deforms a bullet with a transfer of energy. The impact, the bullet being, even if it was a full metal jacket, will deform on impact.
Not to state the obvious, but just to be absolutely clear, we've got 2 entrance wounds and 2 exit wounds on this gentleman.
Correct.
But this is all from one bullet, one shot, correct?
It's consistent with that. So if the circumstances indicate that there's one bullet, one firing, this is the most reasonable way it happened.
There's nothing that you're aware of that would suggest to you or indicate to you that there was more than one shot in this particular instance, correct?
Right. Look, I have 2 through and through wounds. So could they have occurred through 2 separate shots? If that's what the scene and the circumstances supported, I'm not going to be able to refute you on that. But my understanding is if there's one shot, one bullet fired, this is how it would occur.
So what we're talking about here is a bullet that went in through this man's heel, came out of another part of his foot, and then went into his leg and came out of another part of his leg. Is that correct?
Yes, the right thigh and then out the front of the right thigh.
How many autopsies have you done?
Probably is 2,000.
As best you can recollect, have you ever observed or do you have any knowledge of a single gunshot wound taking that particular trajectory?
I've had single gunshot wounds go through both legs. I've had them go through the arm and the chest, through a foot and then the leg, a foot and then the opposite thigh. One does not come to mind.
You would agree that this is a highly unusual trajectory for one bullet, correct?
I wouldn't say unusual. It makes sense. I wouldn't say it's unusual. I would say it's not a pathway we encounter every day.
Okay. Now, when someone has an injury like this man had and aid is being rendered, am I correct that one of the first things you want to do is put a tourniquet on the person's leg?
Yes, you want to mitigate the blood loss. So that's going to be pressure, tourniquet, stop the blood flow from stop the blood flow above the level of the injury.
And that was done in this case, correct? That was administered?
He came in with a tourniquet on. So at some point one was placed on him.
Now, the amount of cocaine that this man had in his system, you testified earlier that it's not part of the cause of death, correct? correct?
That's correct.
However, that amount, it is a potentially lethal amount, is it not?
Any amount of cocaine is technically potentially lethal.
But this amount, this isn't just any amount. This is
a goodly amount, yes.
Okay.
A goodly amount. It's not. It's not.
It's healthy. It's goodly.
Just a small amount. It's it's consistent with recreational use. It's not like somebody you see like a body pack or anything like that. But it's not just. Sometimes we'll see people, regular cocaine users, and they're probably coming down, and they have just a tiny little bit of cocaine coming along for the ride. He's using. Yes.
So this is, we're in Miami. There's cocaine in Miami. But this is not just, like you said, not a little bit. This is a rather significant amount of cocaine that this man took, right?
This is recreational use of cocaine. It's not, like I said, it's not the little bit we see with somebody that's coming down. They're in the active phase of using.
Now, am I correct that that when somebody's using cocaine and they use other substances, particularly alcohol, that increases the toxicity of cocaine, correct?
It can, yes.
Okay. That combination, cocaine and alcohol, it produces a metabolite called cocaethylene, correct?
That's correct.
And in your autopsy, you tested for cocaethylene, correct?
Yes.
And he had 0.150 milligrams per liter of cocaethylene in his blood, correct?
Yes.
And when looking at the alcohol, he had 0.108 blood alcohol level. Is that correct?
Yes, 0.108 in the ocular fluid, 0.107 in the blood.
So if he had been operating a motor vehicle, he would have been driving under the influence.
Correct.
Because the legal limit in this state is 0.08.
That's correct.
All right, so he had this very high amount of cocaine in his blood, along with this amount of alcohol in his blood, which would have been enough to trigger a DUI had he been driving.
Objection, prejudice calls for legal conclusion.
Yes.
And he also smoked some weed too, correct?
At some point he used marijuana. I cannot tell you how he used it, and I cannot tell you when.
Now, doctor, you were asked about whether or not some of these substances delay or could affect how long it takes somebody to bleed out. Can you explain that a little bit more, please?
Yes, so just as I explained before, cocaine is a stimulant, and it, just like the adrenaline rush that will occur when somebody gets an injury, it will increase your blood pressure through constricting your arteries, and it will cause your heart to beat faster.
Now, when someone's shot, do you expect them to necessarily start bleeding out right away, or does it take a few moments before blood starts coming out of somebody's body? I mean, usually.
Oh, when they're shot, they'll start bleeding right away. You may not see it on the outside of the body, but trust me, they're bleeding somewhere. So they get shot in the chest. They are bleeding into whatever space is around them. So in the chest, you have a lot of space for the lungs to expand. They're going to bleed into the chest wall. You get shot in the leg, you're going to be bleeding into the muscles, the soft tissues there. Only when the body is in a position where the hole that leads to the outside is lined up with where the blood is, will it come out. So oftentimes we'll get to a scene of murder. They've got a bunch of holes in their chest. There's not really that much blood out. When we start to move the body and we've tipped it, then blood will start coming out of the holes.
So it might take a little bit of time before you start seeing blood dripping and landing on the floor from somebody who's been shot.
Correct. It just depends how the hole lines up with where the blood is accumulating.
So if somebody's walking or running or in any type of movement, they get shot, but they're moving, you might not start to see a blood trail until they've taken a few steps, correct?
Correct.
Now, So you were asked about whether certain things are consistent with your findings. I want to give you a scenario, and you can tell me if it's consistent with what you found. Okay?
Yep.
So let's assume that we have somebody who is very high on cocaine and alcohol and THC. And that person is running around stalking somebody outside their home. Okay?
Yes.
That person is told to leave. They don't leave. At some point, there's a confrontation, and the person is asked again to leave. The person screams and says, I want to die, I'm ready to die. And then they run towards a house with the intention of breaking into that house.
There's got to be
they
an
have no
objection
right to
here
be
soon. This is a pretty...
And a person fires a shot in that person's general direction for the sole purpose of getting that person to leave, which they have thus far refused to leave. Are you with me so far?
Yes.
Objection, invading the province of the jury. He hasn't finished asking his questions. Let me hear the rest of the question.
He has to finish asking the question. He gets to
Fires a
continue till the
gunshot.
end. Then it'll be
for the purpose
sustained.
of getting that person to leave, which that person has refused to leave up until that point. Once that gunshot is fired, that person starts to leave. You would not expect that person to immediately bleed onto the ground and show where that person was standing at the time he was shot. Is that correct?
He could be bleeding at that time, or he could start to bleed later. I can't tell you one way or the other.
So if blood droplets are found, say, 15 steps away from a front door, give or take, 15 steps away from that front door, would that or could that be consistent with somebody running away from that front door after being shot?
So you have the front there shot. Are you telling me where the person was shot, or?
So the person's running towards the front door with the intent of breaking into this house, which they've been...
Objection, legal conclusion. Evading the province of the jury. Overruled. If you can answer the hypothetical, you'll do so. If you can't,
Correct.
go ahead and hear the end.
The person was told, leave. I don't want you here. You're not welcome here. Get out.
Okay.
I'm not getting out. You're going to have to kill me. Runs towards the door. Shot is fired for the purpose of getting that person to leave. Shot hits.
The witness is like loving this. He's laughing. Okay, first of all, I think this hypothetical is way too speculative. It's allowing the defense to testify, basically. They're saying the purpose of the shot. Why is the purpose of the shot important for the medical examiner to understand? You don't ask the bullet what the feeling is behind the energy it's conveying, right? We don't need that, okay? I think the judge should have sustained the objection because this hypothetical does get heavy into speculation and nearly testifying. It's very clever. Yes, I agree, Ashley. It's very clever, and the judge is allowing it. Maybe she'll continue to allow it. I don't know. But it's all couched in this hypothetical. It's about, would you expect the blood to be found in that area? You know, which is also weird. How soon would you expect there to be blood on the ground? He's an ME, right? I get with his training experience, schooling especially, he would understand how quick the body would start bleeding. But understanding how soon there would be blood on the ground, this is wild. This is a funny one. Let's see. We have just a bit before lunchtime, I think. I'm not sure if we're going to work through lunch today or not. Hey, Josh, with Clark County, I guess I can hear it. Yeah. Did they go to lunch? I think not Clark County, but Brantley Clark. Is it Clark County or Brantley Clark? Anyway, the other Florida case we're recording. I've got the video. I just don't know why everyone had left the courtroom. Okay, we're back.
This man is whacked out of his mind on cocaine, alcohol, marijuana. He's been asked to leave. He refuses to.
She's allowing it.
He's in a heightened state, very aggressive. Screams, I'm ready to die. I want to die. It's not leaving. It's not welcome in the house. It doesn't have permission to be in the house. Has no license or has no authority, no right to be in that house.
He's doubling down.
He's going to that house.
He's
running towards that door. Shots fired for the purpose of getting him to leave, which he has already refused multiple times to do so. Shot goes into his body. Once that happens, he's not going to the house anymore. He's running away. He takes about 15 steps running away from the house, give or take 15 steps before blood starts to drip out and hit the ground. Is that consistent with what you've seen here, with the wounds in this case? Could that have happened?
So you're asking if could he have been shot while still inside the house before leaving?
Didn't get inside the house. He was running towards the front door, is shot, and now the shot is what caused him to abandon his attempt to go into that house.
Okay.
So now he's running away from the house.
Okay.
And he makes it about 15 steps, give or take, 15 steps away from the house before you start seeing a trail of blood on the ground.
Okay.
Is that consistent with this? Does that make sense?
It can happen that way, yes. Okay. Like I said, he could start bleeding immediately or it could take several steps to begin to start bleeding.
So the scenario that I just laid out for you, this is not a wildly impossible or unlikely or ridiculous scenario. This is consistent with what you've seen, correct?
It's one way it could happen. I can't tell you for sure that he didn't start bleeding for 15 steps. I also can't tell you for sure, he would have started bleeding immediately.
And nobody knows for sure except for the people who would have been there, right?
Correct.
Thank you, Doctor.
The state is livid. I don't think that should have been allowed.
Dr. Mathis, you were asked on cross-examination about if a tourniquet was placed on the victim, it would help slow down the bleeding.
If placed tight enough, yes.
You don't know when a tourniquet was placed on the victim in this case, do you?
No.
So if there was a delay in when the tourniquet was placed, would that slow down the bleeding or cause him not to die?
The delay in the tourniquet, he'll be bleeding the entire time until a tourniquet is put on, tightly. So anytime up until that tourniquet is put on, the pressure's not being applied, the wound's going to be bleeding. You may not be able to see it on the outside, but it'll be bleeding on the inside.
So if a person waits 10 minutes to call 911 and the officers then take some time to get there after, would that contribute to the victim's death as well?
Yes.
Now you were asked about the blood coming out, and they're coming out of holes, and it may not bleed at that time, or it may. If a person is running away, would the blood start coming out?
It should, because now you're moving the leg, you're advancing it forward, you're causing manipulation, just like I told you. When we start flipping the body, the blood starts pouring out of the hole. So as you're moving, you should start leaving a blood trail.
You're also asked about hypothetical, so I want to pose one to you. If a person goes outside, they're on the steps, they pick up a gun, they point it at the victim sees the gun, in fear for his life, turns around and runs away, and that person shoots. Is that consistent with what we have here today?
Can you repeat your question?
Yes. A person picks up a gun, aims it at the victim in fear for his life, turns around, runs away, and the person shoots the victim. Is that consistent with what we have here today?
Yes, it could happen that way.
Thank you, Judge. No further questions.
Judge, we agree cross on that question.
Yeah.
Judge, I would ask that we go sidebar.
I haven't heard anything yet, so not at this time. Go ahead.
You were asked about a victim
He
who
loves
was
the
in fear
spice.
for his life, running away, right?
Yes.
That's what you just asked. Would you expect somebody who's in fear of their life to say, "I'm ready to die"?
Objection, Judge. Speculation, maybe probably.
Sustain.
Can you answer that question?
What?
I can't.
Okay.
Thank you.
All right, thank you.
Oh my goodness. This is the ME. This is the medical examiner. The judge allows a question, would you allow a victim to, would you expect the victim to say this? The medical examiner sees dead patients his entire career. None of his patients have said anything. And the judge allows him to answer a question about, would you expect a victim to say X? Wow. This trial is not terrible. This trial is normal. This is a regular, normal murder case. Okay, we've got a husband, wife, common in murder trials.
Yeah, let's go real quick. Back to you. Ready? You guys can self-govern with water in there.
This was bad. These are bad calls by the judge. Now what? Are we just done? We're just headed to lunch? Looks like there was an explosion in Tennessee. Bucksnort, Tennessee. 19 people unaccounted for. A blasted explosives manufacturer near Bucksnort, Tennessee. That's not good. Accurate Energetic Systems does work for the Department of Defense with the munitions. Holy cow. 19 people are feared missing, 1 feared dead. Wow. The trial in Judge Wolf's court is over. Shortest deliberations ever. Oh, man. Yeah, Bucksnort. Yep. You got to name a town something, and why not Bucksnort? Just west of Nashville. I felt the explosion in Dixon. 25 are missing. The building is leveled. How far away is Dixon from the manufacturing facility, Kelly? Laurie says, this judge is getting more and more terrible as the trial goes on. She should have stopped that role playing right at I'm ready to die. All he sounds like is desperate lawyer scraping for self-defense. I'm struggling with this judge a lot. And I would like a lawyer who practices law in Florida to comment on this, but they won't or they can't. Peter Tragos, you can't talk about somebody else who's passed the bar in the state. It's really frowned upon, and it can do bad things to your career. But I think that last decision by the judge, asking the ME if you can answer that completely speculative question, that first of all, the defense knew what he was doing was wrong. When he asks the question, he knows he's pushing it, and he's like, in this scenario, we've got him stalking outside, and he starts inserting a couple things. When she overrules the objection, he doubles down. And now he's like, gets all flamboyant in the story. He's been stalking her, and she's in fear in the house, and he won't leave. And he just embellishes this story to build this up in the mind of the jury. It has nothing to do with the question. Nothing to do with the question. Everything that came before, aside from the positioning of the person who was holding the gun and the positioning of the victim, is irrelevant in those questions. And the judge allowed it over and over and over. I think Peter may know this, Judge. May. I'd like to hear a couple lawyers comment on just this particular portion of the trial with that question alone to an ME from the defense. I realize, yes, I think it's right for them to be able to ask questions and say, what about this scenario? Is it possible that he could have been doing a backflip on the trampoline and the gun dropped and discharged from the ground and shot up through his heel? You can build scenarios where this can work. A flying kick, whatever. Is that possible? And the ME would probably say, yes, anything that can get the leg in that position and have the gun at the right angle is possible. It's not necessarily probable. But he's not a ballistics expert. He's already testified about ricochets and how he wouldn't expect the bullet to go through so many layers of skin or so many objects if it ricocheted first. Does he know what caliber a bullet was? I'm not sure if he even checked. Okay, he's got through and through holes. He didn't measure it and testify that we have a 9mm here. What if this was a rifle round, which travels at much faster speeds than a pistol round, typically? There's a ton more energy. I'm wound up. We need Ian. The ME asking about the scenario of how the shooting and the reason for the shot. And she fires in fear for her life to get him to leave. Oh my goodness. I might be wrong on this one, but you can't watch that and tell me that feels right. That line of questioning just feels like, yep, that's the way it should go. Ian, well, if somebody can clip that and send it to him, that would be great. Not necessarily from me. You can grab it from, I don't know, LNC, Port TV, W, whatever. There's a bunch of people covering it. I think he takes it from Court TV when he does his analysis. Let's see. Have they gone to lunch or are we still at sidebar? I don't know. Does somebody know? I think the jury left, so might as well just go to lunch now. Let me quickly listen in to what's going on down in Florida in the other case. I think it's down here. Let's see, is that 8? No, it's in 7.
You're out. Anything else we need to put on the record before the break? There we are. All right, we'll be in recess until 12:30.
Okay, so they're going to recess till 12:30. Oh, it's only a 6-minute break. Never mind. I'll keep that one rolling. We have 2 more hours of space there. All right, there was some loud talking before the silence, I know, but I didn't catch what it was, and I can't use my replay machine right now because I've got everything recording. Jennifer Cockfield, member for 17 months. I think it's been longer. OG, welcome to the gallery. So do I shower today or not? Of course. It makes you feel like you've got something done. It's useful. Do you know what I did this morning? In addition to going to the store and picking up the groceries, I opened 2 huge bags of candy and just dumped them out on the kitchen table. So we had probably 600 pieces of candy. And then our family sat around talking while we bagged candy into little biohazard bags to give out on Halloween. We now have about 600 biohazard bags prepped. And I think I've got 1,000 bags, but I'm running out of candy to fill them. I've opened 8 bags of candy so far, which means we've bagged about 35 pounds of candy. We need more. Thought you were going to say you ate candy for breakfast. Nope. They're an hour behind us in Bay County. Oh, Josh. That makes more sense. For gossip purposes, Daisy's judge is perfect. Maybe she's secretly Team Daisy. I don't know. Did you hear our song, Kathy? I'd love to get your take on our Daisy in the Wall song. Did you hear that the other day?
Nothing but the truth? I do.
Good thing we didn't go to lunch. What just happened? It was just a break. All right, we're back. I was about to go to lunch.
16. Yeah, 16.
Yeah. Good afternoon. Can you please introduce yourself to the members of the jury?
Yes, my name is Sergio Cremesini.
And where do you work?
The Miami-Dade Sheriff's Office.
And what's your title there?
A sergeant at the moment.
How long have you worked at the Sheriff's Office?
I was hired September 16 of 2013.
What unit do you work in currently?
The Homicide Bureau.
And do you have any training or experience on cell phone extractions?
Yes, I do.
Can you please tell the members of the jury what that is, your training and experience there?
Sure. So within my current role within the Homicide Bureau, I'm the supervisor of a specialized unit within the Homicide Bureau. And within that unit, myself as well as some of the detectives that are assigned to me, we've attended various trainings in the areas of digital forensics, specifically cell phones, as well as just general cellular records as well.
And in order to work in that unit, do you have to go through that training?
Yes, in order to conduct the work that we do, there are prerequisite and required trainings.
And I think you already said this already, but specialized training specifically for cell phone extraction, that's something that you have to do?
Yes, so there's a few different trainings in regards to actually conducting the cell phone extractions that I've taken, specifically by a company called Cellbrite, which is the primary, one of the primary softwares that are utilized in conducting these extractions. And with those trainings, they're broken up into a few different areas, but primarily in the actual extracting or downloading the data from a cell phone or an electronic device, and then processing that data that's downloaded as well.
Okay. And generally speaking, how do cases get assigned?
Are you asking in the context of myself or in just a case in general?
Cell phone extraction, I'm sorry.
So in the case of, or in the circumstance of a cell phone extraction, it could be as simple as the detective, whoever it may be, just picking up the phone and calling and just informing us of whatever assistance they may need.
Okay. And generally speaking, is this, let's say a detective calls you up and says, hey, Sergeant, I want you to extract the phone, or is it randomly assigned?
So within my unit specifically, it's myself and a detective, one other detective that I supervise that has the training and the equipment to conduct that. So within my unit, the phone call would ultimately end with either myself or that other detective.
Okay. Now, were you involved in a case PD 220625210513?
Yes, I was.
How did you get involved in that case?
So in that case, I was provided ultimately with 2 cellular telephones to attempt to conduct forensic extractions.
Who provided those to you?
relevant telephone is from a detective, Daniel Morales.
Now, you said relevant phone. What are you talking about there?
So of the two phones that were provided, one of the phones I was able to obtain a full extraction from due to the password being provided. The other phone was an iPhone that was password protected, and the password was not known. And due to the state of the phone, an extraction was not able to be conducted on that other device.
Now, I want to talk about that for a moment. Did you attempt to extract that cell phone?
Yes, I did.
Were you ever able to extract any data from that cell phone?
No.
Okay. Were you ever provided a password to that cell phone?
I was, but it was unsuccessful.
Okay. Now, when that detective got you the phone or gave you possession of that phone, was that with a warrant or did you just unlock it yourself?
No, it was the device with the accompanying property receipt as well as the search warrant.
Now, how do you identify a phone that you are going to extract?
Well, depending on how it's provided, but typically in an instance where a search warrant is provided, it would be whatever is identifying features are explained in the search warrant, and that then in conducting a physical review of the device to ensure that it's the correct device that accompanies the legal process.
Now, after you confirm that you have the correct phone, what do you do, if anything?
So typically you take that device and you just do a visual of it, ensure that it is that it's working, that it's powered on, and then from there take it to a specialized equipment and then begin the extraction of that device.
Okay. Can you explain to the members of the jury what a Faraday room or Faraday box is?
Yes. So pretty much think of it as a large room that any signal cannot get into. So if you were to take your phone inside, it would be completely shielded from any Wi-Fi, any cellular, or any sort of connection that could communicate with the phone. So it isolates it completely from any sort of outside signal.
Okay. And generally speaking, does data change on the phone?
It can, yes.
Okay. How does it change, or is there anything to stop it from changing?
So with any cell phone, there's always going to be things that change on the phone just by the way that phones work. There's always things happening in the background. There's always applications that are open, and there's always things that are continually evolving. That doesn't mean that the files themselves change, but there are additional files and additional logs and records that occur just with the phone being on.
Now, I know that we talked about this briefly, but once you plug a phone into a computer, what happens with that? Do you download the phone? How do you go about that? Is there a program?
Yes. So in this case, I utilized a piece of equipment manufactured by a company called Graykey. And with that, after unlocking the phone and connecting it to the equipment, it downloads a full extraction of the entire file contents within a phone.
Oh, sorry.
So essentially, you can think of a phone as a library and the contents being the individual sections. So that equipment takes and it stores and copies all of the contents that are on that phone.
Once a phone is actually extracted, do you do anything to verify the data that was on the phone that you properly extracted it?
Yes. So upon all of the data being downloaded, there is a process that's called a generating of a hash. And a hash is pretty much consider a digital fingerprint that can be run or compared against any file. And if just one bit of information, the most minute thing changes, there's going to be a different value that's generated. So that's a way that once that extraction is complete, the state of the extraction and the data that was downloaded can be verified that it is the same and that is continuously the same and does not change.
Okay. Let's talk specifically about when you first extracted this phone. Did you do that and confirm that the data that was extracted was the same data that was on that phone?
So the hash initially is generated automatically in the process of extracting the phone. And then when I take that data and upload it to a second software, which actually interprets the data, a hash is generated again and compared to the initial one, verifying that it is in fact the same data and that what was utilized to generate a report is from the same contents.
Okay. And once that phone actually is extracted, what do you do with that data? Do you give it to somebody? Do you keep it yourself?
Yes. So after uploading it into secondary software that actually takes that file from the phone and turns it into something that you can read, I generate a report and provide that over to the detective to review the contents.
And did you do that in this case?
Yes, I did.
Okay. Judge, permission to retrieve evidence and permission to publish. Thank you. Detective, I do not know if you can see how my screen here, because it's a little small, but can you tell us what we're actually looking at right here?
So this is what's going to be called a Cellbrite reader, and this is it's the end product, so to speak, of what the extraction and the data contained within the phone ultimately, how it ultimately appears.
Now, you mentioned a moment ago that there was a phone that was provided to you by Detective Danny Morales. Is that this data?
Yes. So the case number, there's going to be a case number there at the top left, and that's going to be the digital forensics unit case number that was assigned for the extraction of that specific device.
I want to show you a few specific points from this phone.
You need to step down.
Thank you.
So, Detective, if you could actually, can you just tell us right here what the date and time that this, where it says created?
Hold on a second. Make me to reposition yourself and reposition yourself.
So for this particular file, June 25th, 2022, 3:06 a.m.
Okay, and we see that this video is how long?
6 minutes and 57 seconds.
And we
I'm sorry, I hate to interrupt. Is this in evidence?
Yes.
Do we have to mark it?
It's already in evidence. It's been moved yesterday.
Oh, what number was it?
16.
16. Okay, so remember, folks, this is in evidence. So if you need to look at it in the future as you deliberate, it is accessible to you.
Judge forgot this was admitted.
So
she covers like
how
she's
long is this video?
helping the jury
6 minutes
out.
and 57 seconds.
And if you tell me what the timestamp is right here.
It's at the 6 minute and 7 second mark.
And we see an individual right here. So at 6 minutes, 7 seconds after 3:06, can you generally tell us what time that is?
Right about 3:12, 3:13 a.m.
So this video would have been created, or this portion of this video would have been about 3:12, 3:13, so?
Yes.
Let me just publish this video.
Little warning. Sounds like we're out by the koi pond.
Can you tell us the date and time that this video was created?
June 24th, 2022 at 10:37.
And we see a vehicle and 2 individuals?
Yes.
Okay, and this would have been earlier in that evening?
Yes, the previous day.
Let me publish this video now.
It's gonna be loud.
can you tell us the date and time that this video was created?
June 24th, 2020, 9:43 p.m.
And so again, that 306 video that we saw, this was earlier in that evening as well?
Yes.
Okay, so we've got a kid saying "Poppy, Poppy." Defendant, I think, is tearing up at hearing the sound of her son.
So I want to go back and actually look at a few more things here. Let me open prologue. Detective, I want to bring your attention to these two items under 13 and 14. Can you tell us number 14 what it says?
It's going to be an outgoing call, Marcus, or dial to 9911.
And can you tell us the date and timestamp there?
June 25th, 2022 at 3:21 and a couple seconds a.m. in the morning.
And right above it, number 13, can you tell us what that call is?
So same, just 1 less, and it's also going to be an outgoing call.
So it's fair to say that's a call to 911 emergency services?
Yes.
And the date and time on that?
June 25th, 2022 at 3:21 a.m. Almost 3:22.
The first video that we saw, that first timestamp was at 3:06 a.m. and it was 6 minutes long, give or take.
Yes.
And you testified earlier that that means with that timestamp of when we saw an individual walking in front, that was about 3:11, 3:12, 13. Is that correct?
Yes, correct.
And obviously 3:21 is a 10-minute delay.
About.
Let me move on here, and I'm going to scroll down to the bottom of this video where it says social media. Can you just tell members of the jury what these two things are right here?
So the first one would be Facebook, and the usage of just the Facebook application, and then go to TikTok, another social media application.
Sorry, Facebook and TikTok are social media, in fact?
Yes.
Let me ask you about Instagram. Instagram also a social media account?
Yes, Instagram is actually currently owned by Facebook.
Okay, if you could tell us what we're looking at right here.
So this is going to be within the user accounts section of the phone extraction, where it's going to categorize, just generally speaking, any accounts that were on the phone. Not limited just to social media, but any email accounts, social media accounts, things like that are going to be categorized in this section. And this one specifically is a Instagram account that had been utilized on this cell phone.
Okay, and this Instagram account would have been utilized on this phone?
Yes.
Meaning that this is this person's Instagram account?
I'm sorry, ask it again?
This Instagram account would be belonging to this phone or have been accessed by this phone?
Yes, this is indicative of that account having been utilized on that specific device.
And if you could just publish the numbers to the jury of that right there.
Daisy Link.
Great, I have no further questions, Your Honor.
It's Daisy Link's Instagram account.
No, Your Honor. Thank you.
They played 3 videos.
All right, folks, we'll go ahead and take our lunch break now. Let's come back so that we're ready to start right at 2 o'clock. So I'm giving you an hour and 15 minutes to plan to eat and also travel time. There should be less foot traffic in the building today. We don't have more than obviously on Fridays. These are my instructions about ignoring parties as well as in sleep. You can bump into them in the hallways, etc. Please don't talk about this case among yourselves, and please do not do any research about this case. if you become aware of any violations of the orders that I remind everyone every day, please bring it to my attention as well as my daily work. He will take your notes, just like he's been doing all week, and he'll tell you where to meet him so that we can reconvene and start talking at 2 o'clock.
Third floor, please. All rise for the jury.
Okay, Skechers, Nike, Asics. Don't know that one. Don't know that one. Maybe Converse. Don't know that one. Those were obscured. It was the best shot ever, but they just stepped to the wrong place.
Sorry, jury has left. What pregnancy you just testified to, the jury can't take it back with them, right?
Well, so this is her phone. What we can do is Mr. Thomas and I can sit down and agree on certain items to put into a demonstrative to send back to the jury. Because obviously there are stuff on this phone that cannot go back. It will obviously be depending on cross-examination and rebuttal, because there are text messages I intend to publish to the jury from this phone on cross and potentially rebuttal as well. But we can sit down and
Okay, cross that bridge once you get there. If you guys don't do that, that's not possible. They just ask to see certain items and then we just publish in open court.
Yeah.
All right. Should we come back in about 45 minutes? I'll give everyone a 45-minute lunch break. We'll come back at 1:30 and then we'll go over the statement. Does that work?
We just received it. If you could tell me how long.
Yes, Your Honor, it's an hour, 32 minutes, and 26 seconds.
So we should be able to rest today.
All right, fair enough. I just want to make sure that you show the areas that are agreed upon for the redactions, the areas that are not agreed upon for the redactions at 1:30 when we come back. I can give you my ruling.
Sure.
But it seems like it's 90-95% of the parties are agreeing, right?
Yes, Your Honor.
And
I actually don't think there are any disagreements. I'm sorry.
we're not going to be using any written transcripts for them to follow along.
No, unfortunately, as I mentioned to the court in an email yesterday, Mr. Tomas, the vendor, for whatever reason, did not provide a full transcript. The only thing that we were able to do was generate an AI transcript.
Look, it is what it is. I think at the end of the day, unless it's an agreed upon official transcript, they always rely on the evidence that they're reviewing, right?
Yes.
That's the default instruction. So, okay. Mr. Tomas, unless you agree that this AI generated one can be used as a demonstrative aid, that they shall rely on their memory. I'm sorry, or if you want, we can show them these, the AI generated transcript. If you agree, it can be used as an aid.
We're going to show them the AI generated transcript.
Tell them that at 1:30.
Your Honor, one of the issues I'd like to raise with that is that that doesn't have the appropriate redactions to match up with the video.
All right, then forget that idea.
Oh my goodness.
All right, so we'll just look at the video, and, so we'll come back at 1:30, okay? Actually, what do we do? We'll come back at 1:35, so everyone can have the full 45 minutes. 1:35. My meeting is still open.
1:35? Or
Yeah,
45? 1:35, all right.
1:35, sorry. Okay, offer
I'm not sure if she's a new judge or if she's just not a judge, just pretending to be one. She's asking the prosecutors what to do in the case. So what do you want to do? Should we do this? Is that? And he's like, no, let's do it this way. Okay. Transcript? Do you have a transcript? No, we don't have a transcript. Okay. It's okay. We're just going to give the jury AI generated copies of the transcript. Are you guys all cool with that? Oh, no, we can't? Oh, okay. No, I guess we won't do that. She is a not good judge. I'm sorry. Miami-Dade, do better. Do better. She's been a judge since April of 2020. Did she just get re-upped? What is it? They're normally in for 4 years. It's embarrassing. I have zero love right now for her. She just plays a judge on TV. Most of that was COVID, says Tom. First 2 years didn't count, is what you're saying. So she's been a judge for about 2 years. A real judge. I wonder what her other cases are, if she's got some. Yeah. All right. Let's see. We are going to we're going to go take a lunch because I need my blood pressure to come down. This case is just, it's driving me nuts. Not just the audio. I mean, the audio is an issue. I'm doing what I can to fix it. But quick explanation. What happened to the little videos they were playing off the Celebrite report of the extraction from the defendant's phone. There were 3 videos that were filmed the night before on her phone. They were just, it sounds like filmed in the house. One of them I could definitely make out the sound of her child, her son. She got really emotional when she heard his voice. But I think they were shown probably because the son was saying something about Poppy, which most likely was a word for his dad, which would be Pedro, right? The victim, which would show that they were together at that time. Okay. It sort of defeats the whole argument of him not living there and stalking her, because the night before, just a couple hours before, they were together in the house. So that's why that was shown. But anyway, Brandy, I'm looking for something. But I'm not seeing it yet. All right, we're going to go to lunch. That's it. I can't be any nicer than I'm being right now to her, and I need to do better. It's Poppy. All right, we have a portal set up. We're going to portal over to the afternoon session. It's already in place. I think we've got the winner already selected. It's going to be good. I did run to the post office. My daughter did. I picked up these soothing lozenges, honey lozenges, Beekeeper's Naturals. I'm going to give them a try. They can't be as bad as the pecan I tried yesterday from the sidewalk. So we'll give it a try. Thank you very much. We're going to be coming back at 1:30. 5 minutes later, the judge will be back in the courtroom with the lawyers, going over the testimony that they've extracted from the 11-hour interview. It's down to like an hour and a half. So it looks like we are going to rest today for the state. So tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again at 1:30 this afternoon. So please do that. We'll see you over there on the other side of the portal. Everyone grab your portal buddy's hand. You can make the trip safely. The portal is off and automatic. Mel, enjoy the shower. Everyone grab hands. We're all good? All right, here we go. See you guys on the other side.